Wait, please, your lordship. My lord, I beg to mention for bail application which was filed on 14th, my lord.
Bail application.
May please, may please, your lordship. Like
Bail.
to mention, no, ma'am. For adjournment, my lord. Item 53, my lord. I am appearing on behalf of Mr.
Item
NN
number?
I am appearing on behalf of Mr. NN Upadhyay, my lord. 53, my lord. He is in bereavement, my lord. His father
It is stated in the that Mr. N.N. Upadhyay, a prayer is made on behalf of Mr. N.N. Upadhyay for an adjournment in the matter on the ground that he is in bereavement. Prayer is not objected to by the Illinois
I'm
Council.
praying for a date, my lord. 28.
Prayer is not objected to by the Illinois Council for the respondents. You have informed the respondents?
Yes, my lord.
Accordingly, registry to list this date after 2 weeks on a date to be fixed by it. Matter be not treated as part and of tied up matter with this court any further.
My lord, date may be fixed.
It will come. Criminal appeal after the Diwali.
Please, your lordship. I beg to mention listing a bail application, lordship.
The orders, delivery of orders matters, we will take up after the list is completed.
That case, I just wanted to mention that item number 35, there is a typographical error.
20,
35.
35.
Lordship, the file which is here is of 2015 and they have put in up to 2025 in the cost list.
Yeah, Sutin is not done. No, the file is here. It's the Subhash Banik. Oh, this is another matter that has come.
Yes.
This is not reserved for orders. Leha, item number 35. The matter has been wrongly listed. Full stop. The matter which was required to be listed for delivery of orders is WPC number 2540-2015. Full stop. Registry to take requisite steps for rectification of the same and for listing of WPC number 2540-2015. For some, in view of the above, registry to list this matter before the appropriate bench after 2 weeks on a date to be fixed by it. Itu ahamai. Tata date didi bole. You have made your submissions. They were supposed to file. Yes, madam.
Only one judgment today I am want to. One paragraph, kindly see paragraph 13.
Which the judgment is 2016, 2001.
2001.
6 SCC 311.
Paragraph 13.
13.
Court of Appeal or Revision has to examine last 4 line. Examine specifically whether such erroneous.
But this is in relation to a proceeding before a wrong court without jurisdiction. Huh? That issue is not arising in your.
But even then, the court held that if it is an
That is in that context.
context, yes. Only revision or appeal, let court has the power.
That's in a
That is
different
the only-
context. Otherwise, also we have
Okay.
the inherent power if there is a culpable illegality with regard to the jurisdiction. Yes, madam, what is the decision you want to rely?
Lordship, we were asked to file a brief note. Also, what the judgments in support of
Give me the citations. Heard the Learned Counsel for the parties at length. Also, hearing concluded, a registry to list this matter again on Kundina Pari hai ola khali thaka din 30/10/2025 for delivery of orders.
May I please your action? Some other persons acquired my lord 5-7 years back.
Okay.
I could not.
Mr. A.K. Talukdar, Learned Counsel for the petitioner, submits that during the pendency of the present proceedings, the appellant had passed away. Full stop. Accordingly, he submits that the present appeal has been rendered, stands abated. Full stop. Prayer is not objected to by the Learned Counsel for the respondent. State. Full stop. In view of the above, the present appeal stands closed on being abated.
But whether it will be required to have a call for a report, my lord, whether I am right or not, my lord.
You have made a submission, that is it. Finished. What is more required?
My lord. Not for the right person, but not his wife,
You-
other person.
You got your information, you have made a submission, we have closed it as it would come a bit. That's all.
Yes, your lordship.
Yes, Ms. Allam.
Appellants, they were convicted under section 2 years with fine, my lord, for another. I'm just reading the FIR, my lord. First of all. Submission is there.
But this informant passed away.
The informant passed away, my lord. The incident is that, my lord, that the boy of that child of Farooq Ahmed, my lord, pulled the frog, my lord, as per the my lord, evidence of prosecution. Thereafter, she slapped that boy, my lord, and thereafter she was chased and went to the house of Parimal Malakar, my lord. There the incident happened, my lord. And my lord, wife of Parimal Malakar is also a witness here, my lord. So thereafter, my lord, after 2 days thereafter the incident, my lord, commit suicide, my lord. And thereafter, this FIR has been registered, my lord, along with other sections, my lord. Go by the evidence, my lord. 1, 2, 3 are declared hostile, my lord. And
Because that contradiction was brought on record through the IO. The IO has clarified that during the 161, they had stated all these facts. But during the trial, they refrained from reiterating that.
I kindly say PW4, their own person, my lord, lordship, I will just read some
But
of the.
that aspect has been dealt with by the learned trial court. It has gone into that aspect and very nicely dealt with.
My lord, very nicely dealt. See, my lord, the provisions under section, my lord, that Atrocities Act, my lord, that is what
No,
is
that
investigated by the-
section 3 of the SC/ST Act, that was not taken care of because that was not brought in because 354 was attracted. It says that 354 is attracted and the conviction was under 354, right? But with regard to 306, the court, I don't know, they were material, but still the court had held that is not attracted, right? But the incident, if you see, it indicates that the reason for her abetment to suicide was the act on the part of the accused persons.
they want visar from that person. That means they want some village male to be held because of that.
No,
incident, my lord.
Bichar means, see, the two
But
communities
because-
are there. So both the communities were requested by the girl for justice. Bisar means justice.
Yeah, justice, my lord, yeah.
When she did not get it, she committed suicide. Maybe she was too disturbed by the act committed upon her by the son of the accused number 1 and the accused number 1 in the house of Parimal Malakar.
But in the house of Parimal Malakar, my lords, only that boy, my lord, along with some children were there. As per the
It cannot be children that the fact the learned trial court has
My lord,
gone
my-
into that aspect.
yes, that's why, my lord, I just want to, my lord, just read out that all those, my lord, PWs are few PWs are there, my lord.
Hmm.
Because I am not reading 1, 2, 3, and 5, my lord, because
Hmm.
they are declared hostile, my lord. I am
Hmm.
just reading 4, my lord. PW4, my lord.
Now, the declaration of hostile witness, the contradiction that they brought on record was put to the IO, and the IO was, you have not crossed the IO on that also. Yes, what do you want, PW?
PW4, my lord.
PW4, yes.
Purna Malakar was my niece by relation. We are of same homestead, my lord. She about 1 year back by pouring kerosene while committed suicide. The incident of pouring kerosene was happened at about 12 or 1 o'clock at that day. About 2 days back of her death, one day she went to the shop of accused Farooq, where a quarrel took place with some young boys. She was assaulted by the young boys. She then took shelter in the house of Parimal Malakar. I went there in the compound of Parimal Malakar and tried to disperse the boys. I found the young boys were assaulting Aparna Malakar. I rescued Aparna. By this time, on hearing hue and cry, many people went there. I know all the accused persons. They are of my village. The reasons of committing suicide is not exactly known to me, but it may be due to her assault by the young boys. I cannot say whether there was any bizarre relating to the said assault. I cannot say the name of the persons who assaulted Aparna Malakar. Cross-examination, I did not see the occurrence of the alleged took place.
Naturally.
So, my lord.
But he is a witness to Parimal Malakar's home.
Oh, my lord. So, my lord, the boy was, as per the FIR, my lord, it was said that, my lord, that accused person chased and assaulted. But here, my lord, the persons who were the eyewitness to the incident, it says, my lord, the son of Farooq, my lord, along with some boys, young boys, they have chased and they have assaulted.
So who is the son of Farooq here in the
My
present
lord,
appeal?
in the entire evidence, my lord, I don't
No,
find
no,
the
no.
name.
No,
No,
who is the son otherwise?
He's no, they are the brothers and other neighbors of that, my lord, that person.
Masuk Ahmed is who related to Farooq Ahmed in what connection?
My lord,
All are brothers.
All are brothers, my lord. Farooq Ahmed is that boy's father, my lord, Farooq Ahmed. Masuk Ahmed is his brother. Ashok Ahmed, Abdullah and Lal Mia, all are sons of Bolu Mia, my lord. One family, person of one family, my lord. The boy is the son of Farooq Ahmed, my lord.
The mother of the victim was not examined.
Mother of the victim, my lord, she was not examined. And this father, my lord, during the trial, my lord, at the beginning of the
died.
trial, he died, my lord. Thereof the aunt, my lord, Sarojini Malakar, she was examined, but she was declared hostile, my lord. Then Sabita Malakar, my lord, is a wife of Parimal Malakar, my lord, the house where the incident happened. She also stated that some boys were there, my lord, but she was declared hostile, my lord. But Harendra Malakar, though he make the same statement, my lord, but he was not declared hostile, my lord. Bhaskar Malakar, my lord, again, my lord, same statement, but she was declared hostile, my lord. Then I will read Opu Malakar, my lord. Opu Malakar, statement of Opu Malakar, my lord.
Opu Malakar.
Yes, my lord.
PW?
PW6, my lord.
He also is not an eyewitness.
Yes, but PW4, my lord, he's an eyewitness, my lord. And they are from the same family, my lord.
No, not an eyewitness to the incident happening in the shop.
Yes. But yeah, that assault.
But he is stating a fact. This
Yes.
is a fact he is stating.
Yes.
Cannot be said to be a per se hearsay witness only. He is stating a fact,
Yes.
which he learned from the father.
Yes, my lord. Yeah, even my lord.
Earlier incident.
Even my lord, if you go by the statement of PW7 also, he said that that person, the father told him, my lord. Yeah, let us read PW6 once, then I will go to PW7, my lord. He is an elected member of the locality, my lord. Ward member. Accused person are of my ward. This is Aparna Malakar and her father were of my ward. At about 1 year back, one day when I returned from my work, I heard that Aparna Malakar by fire committed suicide. About 3-4 days prior to her death, one day in the afternoon time, hearing hue and cry, I came out and saw Aparna Malakar was being chased by some boys. Aparna Malakar was being chased by some boys of our village. I could learn that when she went to the shop of accused Farooq, one boy pulled her frog. For that, she gave slap, and after that, she was being chased and assaulted.
So, the reason for the chase of the victim girl is coming out.
Yes. Yes, but that was done by the boy, my lord. What my submission is that, my lord, these appellants, my lord, who are convicted, my lord, they were not there, my lord, because his son, Farooq's son, and rest, my lord, other are his brother of Farooq, my lord. He then took shelter in the house of Panimul Malakar. After that, I went there. By this time, the boys left the place. Father of Aparna did not seek any visa to me. 2-3 months back, Sunil Malakar, the complainant of this case, died. So PW7, my lord.
You come to the evidence of the IO PW10. This contradiction was put to him. PW1, PW2, PW3, PW4, PW5. Everything was put to him. See the cross.
On 7/6/2011, at about 5 p.m., the FIR was received in the PS. I visited the place of occurrence, the house of the victim, at 5:20 p.m. on the same day. I left for the PS at 6:30 from the place of occurrence and arrived at the PS at 7:15 p.m. During my stay at the place of occurrence, I recorded statement of all 7 number of witnesses. In the index of Exhibit 3 under column D, house of Sudhir Malakar is shown which is adjacent to the place of occurrence where the alleged assault was made, but I did not examine Sudhir Malakar. Sudhir Malakar. On being entrusted with the investigation, I directly visited the place of occurrence, though I had knowledge that deceased had already been shifted to hospital. Inquest done at Civil Hospital Karimganj by ASI Gaur Singh on 7/6/2011. The same was initiated 4 p.m. and completed at 4:30. It is seen that PW 5, 6, 8 were present at the time of inquest at Civil Police Station. The distance between place of occurrence and Karimganj Civil Hospital is about 2.5 to 3 kilometers. I record the statement of witnesses on 7/6, that is on the first visit of the place of occurrence. I recorded all the statement. I recorded all the witnesses. I record the statement before seeing the dead body of the victim.
It is not a fact.
That whatever omission being brought by the prosecution side regarding PW 1, 2, 3 and 5 were not actually stated by them to me. I cannot say the date of postmortem without seeing the diary. It is not a fact that I submitted charge sheet in connivance with the complainant without having any merit of the case.
So how do you, and in your,
PW4, my lord, PW7, my lord, PW7 we seen, my lord.
and in the 313 also, there is no explanation.
Cook's son pulled the frog and found by that girl.
No,
and
the
after the
statement
incident-
of PW 5 before
Yes,
the
PW5.
police.
PW5 I will read, my lord.
If you can come to that same statement of the IO. Same statement of the IO statement.
Yes, my lord. I have statement, my lord.
And just above the cross, paragraph above the cross.
Yes. I also record the statement of PW5 on the same day, who stated before me that on 3/6/11 in the afternoon, Aparna Malakar, aged about 18-19 years, went to the nearby shop of Farooq Ahmed, where the son of the accused misbehaved with her by pulling her frock. She then gave a slap to the son of Farooq Ahmed. As a result, accused Farooq, his brother, Mashuk, Ashok, Lalmi and Abdullah assaulted her. She then chased by them and dragged out from the house and was assaulted.
So
PW5.
that means the accused appellants herein.
Yes, appellants, my lord. These Farooq Ahmed are appellants, my lord. PW5, my lord. There is what he say, but what
Okay.
PW say in the deposition, my lord. Was declared hostile, my lord, PW5. On query upon, my lord, I will just read, my lord. Accused
On
person-
query.
Yeah, on query. On query, Aparna told that when she went to the shop of Farooq Ahmed, she was ill-behaved by one boy who was then slapped by her. After that, some boys assaulted her. The complainant, that is the father of the victim, sought Bisar in the village, but there was no Bisar was held. After 3-4 days, I heard the victim committed suicide by pouring kerosene. My lord, may I kindly PW6, my lord, once, my lord. I will read, my lord, from the last 5-6 lines, my lord. Before 3-4 days prior to her
Indian
death.
Evidence Act to, sir.
Before 3-4 days prior to her death, one day in the afternoon time, hearing hue and cry, I came out and saw Aparna Malakar was being chased by some boys. Chased by some boys of our village. I could learn that when she went to the shop of accused Farooq Ahmed, one boy pulled her frock. For that she gave slap, and after that she was being chased by the chase and assault. She then took shelter in the house of Parimal Malakar. After that, I also went there. By this time, all the boys left the place. Father of Aparna did not seek any visa to me 2.5, that is 2.5 months back. Sunil Malakar, the complainant in this case. And PW7, my lord. PW7 said, my lord, I knew the deceased Aparna Malakar, my adjacent house on the east of the Jitendra Malakar. I know all the accused persons. They are of our village. Aparna Malakar died by self-implementation about 1 year back. At the time of self-implementation, I hearing alarm, rushed to her house and found she was lying with fire injury in her courtyard. I pouring water extinguished the fire on her person. She was taken to hospital where she died. The occurrence was happened in the morning around 7:30, and so far as I know, she died in the hospital about 10:30 a.m. I heard that pouring kerosene oil on her person set fire and committed suicide. I gave statement to the police. I cannot say the reasons behind her suicide. After the death of Aparna, when I asked her father, it was told that on 1 or 2 days prior to her death in the shop of Farooq Ahmed in the daytime, one boy pulled her frock, for that she gave a slap. After that, children rushed towards her and she came to her house. Her father had expired after the incident. Children, my lord.
Hmm.
Why? Parents with that girl.
You mean to say that doubt arises whether it is the accused persons or or
Yes.
somebody else who had done
Yes,
this?
my lord.
Yes, Mr. Gupta. Hmm.
I remember. Here, that, my lord. Being that
Incident is of?
And my lord is that occurred on my lord 3/6/2011, my lord. My lord, she died 7/6, my lord. I think that pouring of kerosene, my lord. That left.
Okay, let us see the judgment. Para 15.
From the above argument and discussions of the evidence, some facts that is outraging of the modesty of the victim in the shop of accused Farooq, assault of the victim in the premises of Porimal Malakar, and commission of suicide for want of bisar only for getting rid of insult and slur life are found to be strongly. Under such circumstances, the alleged incidents being taken place in the neighborhood of the victim, it is considered to be a very unnatural that she might not have disclosed the name of all or any one of her assailant to any of the witnesses. It is also very difficult to conceive that some children or boys of the same locality in presence of elderly persons could have assaulted young girl of 18-19 years, and that too dragging her out from the house of someone of the same neighborhood. Had it been so, would have been disclosed by the witnesses, especially on the ground that there would not have any risks of conviction or sentence of the juvenile. And similarly, such act could not have restrained by elderly persons without any fear. Had there been any involvement of any boys or children in the act of dragging out an assault in the courtyard of the Porimal Malakar, the same would have been reflected in the statement of witnesses recorded by the IO, and the same was also would have been brought by the defense in the cross-examination of witnesses IO. In absence of such evidence, the contention of the involvement of young boys and children is highly improbable under Section 11 of the Evidence Act. Rather, the contradictory statement as brought in the evidence of the IO may be considered as most relevant under the section of the Act. That apart, by the act of slapping of the boy in the shop of the accused person by the victim, in protest against ill treatment, immediate reaction by the accused Farooq and his brothers is very natural under the feeling of insult. As such, probability of involvement of another non-affected person in the subsequent assault to the victim is very remote. Under such circumstances, the prosecution's suggestion that victim girl belonged to scheduled caste community, which is a minority in the village in comparison with that of the community of the accused, and that may be the probable reason for not disclosing the name of the elderly accused person out of fear, and also for disclosing the name of the elderly fear, and also for maintaining future good relation between the two communities can be considered as suggestions, not merely made hypnotically only.
Now come to para 17.
Yes, my lord. Evidence reveals that before beginning of the trial, the complainant died. Accordingly to the learned defense counsel, exhibit 2 is not properly proved by examinations of any scribe. As such, the IO proved the FIR and there is no denial of signature of the complainant in this complainant. This plea of non-proof of the FIR is considered to have got no force. Although FIR is not a substantive piece of evidence, but for the death of the complainant and there being no inconsistency of the contents of the FIR with that of the established fact, and also consistency with the contradictory statement confirmed by the IO and the FIR cannot be altogether disbelieved. The defense side in the cross-examinations of the PW has brought that there was no bad relation in between family of the deceased and the accused person. That being so, under the facts and circumstances of the case, and view of the foregoing reasons, the discussions and evaluations on the evidence, I find no reason to disbelieve that the content of the where the accused persons were implicated. Therefore, if the FIR is read with other evidences, both circumstantial and indirect, as discussed earlier, it would clearly show that an accused persons, but none committed the offense of assault in the open daylight. It is a case where that assault has been committed by the accused person, my lord, and that is the reason for which, my lord, as per the court held, because the assault committed by that to that
Because
girl,
you
my lord.
see, the other witnesses have said many things in the during trial. They may be under threat also. We don't know. That's a presumption. But they were declared hostile. Their contradiction was brought to the IO. And the IO repeated the names of the persons mentioned in the FIR. So in that view of the matter, there is a chain which is there.
What about, my lord, the PW5, my lord, PW4, my lord, PW6, PW7, my lord? They have deposed. because
Okay,
they are
maybe not
declared
you.
hostile.
Maybe
Yes, yes.
let us look it as at a different angle.
Yes.
The girl's suicide is because of this incident, right? Right or wrong?
Yes, regarding incident, my lord, as per this, yes.
Then para 19.
As regards the alleged
There is
commission-
this finding coming of the trial court. How is this finding to be sustained? Para 19.
there is no evidence to suggest the accused person had any prior knowledge that the victim opponent would take such a decisions for commission of suicide. That apart, their act of assault or outraging of the modesty is found to be single and isolated act. Therefore, the evidence is considered to be insufficient to bring home the offense under section 30.
Did not be. There is a connection, direct connection.
There is a connection.
There is a direct connection.
Direct.
If the 354 is held, established against you, 306 follows.
But here, my lord, if lordship sees, my lord, paragraph, what is it says, my lord? In view of the above discussion, contention and evidence, it is held that the prosecution has been able to prove case beyond reasonable doubt under section 354 IPC.
Okay, but this is an appeal. I have my,
Yes,
I can appreciate. But if
but-
354 we upheld, then 306 will follow, given the fact
by the village- by
that
the
is
village.
how one perceives.
Yes,
If it is a abatement is what? What is abatement? Read 306.
yes, my lord.
Correct me if I am wrong.
If any person commits suicide, whoever evades the commission of such suicide shall be punished with imprisonment of either discretion
So
for
whoever abets.
Yes.
So the reason for the suicide is
Not
the
getting
assault.
Vichar, not getting Vichar from the local people.
Because Bichar for what? Because of the assault. So assault has a direct connection with the,
Submission is that, my lord, they or the PWs, my lord, is, my lord, by that boy to that girl, my lord, not by the appellant, my lord, or the accused person, my lord. That is what I want to submit, my lord.
I think 306 will also be attracted here. And the incident against these accused is the chase
Yes.
and Parimal Malakar's house, not the frock. Not the frock. Frock, somehow that boy has gone. Or maybe she had taken her,
First, she
giving a slap, she had done it. Now you tell me why 306 should not be brought in.
my lord, was chased by that. Let us read.
That
let us-
has been disbelieved by the learned trial court, and also the FIR stands established with the evidence of the others, including the IO. Contradiction has been, that's the way how you highlight a contradiction.
My lord, the person Savitra Malakar's, my lord, deposition, my lord. She is a wife of Parimal Malakar, my lord. Then there, my lord, there were only children who were present there, my lord. Not, she was not persons, my lord. The appellant.
That has been dealt with by the learned trial court, saying that the accused were deliberately tried to be protected. Yes, anything more? We'll consider, don't worry, we'll consider.
Last three lines of para 20 says, my lord, having due regard to their statement and commission of an offense on younger, who being humiliated committed suicide for not getting justice from the village elderly person, especially from the accused person. My lord, she wants justice from accused persons and other elderly person, my lord. Yes, since it was not responded, my lord, is so she commits suicide, my lord. But the persons to whom the has been given, my lord, did not they respond, my lord. Whether they will be, my lord, because the assault has been committed by that young
Assault,
boys.
no. That is a statement, but
Yes.
we have the IO. Well, how can we discard the IO statement? Because that is corresponding to the FIR.
Yes, my lord,
The man is not there.
yes, as regard, my lord, PW 1, 2, 3, and 4.
All hostile.
Yeah, hostile to that extent, my lord. Yes, my lord, contradicted, my lord. But my lord, as regard to my lord, PW 4, 6, 7, 8, my lord. Statement of PW 4, 6, 7, 8. They also did not state, my lord, that accused persons, my lord, this appellants, my lord, they chased, my lord.
And say that has to be taken with a pinch of salt because they are there and they deliberately are not saying. They are related
Yes.
to the victim.
Page 4, my lord, yes, PW 4, my lord. They're all related and diverse, my lord.
For PW4, Farooq Ahmed and the others are young boys. Why? She is 85. So these young boys and not somebody else.
PW 7(6) about child about children, my lord. If we see, my lord, PW, my lord, PW 6, my lord.
PW6, huh?
Yes, PW 7, my lord. Last three line, my lord. After that, some children rushed towards her and she came to her house.
Young boys, some boys of our
Yes,
village.
after my lord,
Nowadays,
the
boys,
one boy pulled her frog and PW 7, my lord.
Laura is becoming boys. Laura can have different connotations.
PW 7, it is in there in is already, my lord.
Even
Yes,
I say Mur Logol Laura at this age also.
But here it is written, my
It's
lord.
a relative
after,
term.
After that, some children rushed. Children is there, my lord.
PW6.
PW 7, my lord.
That he has heard.
Yes.
He has not seen it. He only heard it. Okay. Yes, Mr. Goswami.
Ever I have submitted my P 6 and my lord 6. Only thing my lord says that 10 part my lord.
Hmm.
My lord evidence of IO my lord. He has names of all the appellants.
That is
Apart-
from the mouth of where the evidence under 161 by those 2,
other
3, 4.
witnesses. Yes, my lord. So the name of the boys have come, my lord. But the my lord trying to project my lord regarding the children, my lord. My lord, it is a translated that means that maybe that is why my lord I that my lord that suicide as my lord attempt has been made and he was committed.
But-
At first I thought it after reading my lord first I thought it's a case. Last part when
306 was attracted.
attracted.
Now, prosecution story was this. Now let us see the other side. Whether the story which is being projected has some semblance. Now, there is no evidence, literally. Eyewitnesses are not there.
Adding
Eyewitnesses naming the accused are not there.
naming the
Accused are not there. Contradiction in the statement with 161 is only a part. Only a part. There has to be something more than that to hold conclusively that no, it is these set of people who had chased and led to the death or suicide, abetment of suicide of the accused. Now, basing on these materials, can it be conclusively said that no? Or is there a doubt coming up?
my lord, though the names were not uttered, probably we
No,
the-
assumption how far we can go.
there-
Because
there-
why I said in para 15, I wanted this from the mouth of Mr. Alam, but okay, fine. Para 15, these are presumptions true. But they may be, they should have,
yes,
but they have not.
in as per PD.
No, this para 15, the conclusion drawn is on ifs and buts, not on material. You get my point? What do you have to say on that?
As per the my lord, but
On trial court.
yes, trial court, but as per the evidence, my lord, lordship as a appreciate it either way, my lord.
No,
So
either way,
because
this either way,
Yes, because
it would come some boys.
yes, some boys, my lord. Some boys has to be, my lord, whether some boys were actually known to all the all the witnesses.
Accused and they refused. Then we'll have to have some material somewhere.
Some
161 cannot be, it can be only used for
contradiction and some-
contradiction. And you have not used that for contradicting you have only cross-examined them, but you have not contradicted them regarding the names.
Yes, my names, my lord. And that we have to see, my lord, whether those all the names were whether they remember by the are known by this.
No,
witness,
no.
my lord.
If you come to PW 2,
Why the IO comes in, my lord.
because here there is an evidence of PW 2 cross by defense. When I found Aparna Malakar standing in front of the house of Parimal Malakar, I did not see any of the accused person. In our locality, there are 65, 70, including all communities, so and so. Accused persons are of lower caste. There was no bad relation in between the family of the deceased and the accused.
That is why, my lord, that is why they are declared hostile. So we have
No, after hostile,
yes,
they were crossed
Yeah,
and
crossed
then they
by
were
the-
examined by the
yes,
defense.
because, my lord, that has to be seen on the side of, my lord, PW trying to hide something, my lord.
But how do I uncover that? I cannot presume that.
And your lordship will see
Can FIR be a basis for conviction?
where plus the chain of circumstances. Otherwise, my lord. But if we see lying on the other two witnesses, a conviction can be sustained. That has to be taken into account. All the evidences same quality, my lord. Quantity, my lord. It's a quality, my lord.
No, fine. Now these young boys, who are these young boys? Can I definitely say that it is
But my learned friends, my lord. That, and there is also, my lord, no death because it has come from the mouth of the IO. There is no evidence to that effect.
PW2 says that they were not there.
After DW, my after the IO's witness, my lord. Agree?
So 7, there is no hostile declaration. He also does not say children. So a doubt on a reading of the evidence as a whole, forgetting the contradictions of two, three witnesses, let us ignore that. Even the others witnesses which are there, they don't bring on record doubt. It is there, but beyond reasonable doubt.
That is, it has come out from the four eyewitnesses. Children, but there might be some.
No, they are
reason-
in their age. They are 35, 36, 37. So children will not be the accused or they'll be of the similar age.
Similar, and the incidents were not denied by them, and even then it has come out from the first time from the IO, my lord. But there
Because
is-
the
because
first
they are-
incident which occasioned in the house of, in the shop of Farooq Ahmed, accused number
Farooq.
1, that is not an issue here. It
there
is
a
the incident in Parimal's house
house.
where the starting point is.
Yes,
And thereafter the suicide. Suicide he has given up. And no appeal against that by you. Okay. We'll consider. Disposed of. I'm only on that whether we can categorically say that yes, something, some material.
so even names are not then.
Because on the basis of mere contradiction, I can't go and hang him.
Then a chain, my lord, which then, my lord, it will.
No, the
enough.
chain also, there has to be something to only the FIR is there. Clear. The rest, there is nothing.
They have said everything, my
No. The two words I use: young children, young boys, and children.
young boys.
The learned trial court says that he draws a theory that children is there, then the elders would have stopped them. Young boys, elders would have stopped them. To protect the elders, they have said this. That has to have some basis somewhere. It's not there.
Young boys is, my lord,
Hard case, but
up to,
fine, can't help it. Benefit of doubt.
but in my humble submission, young boys, if we take the.
No, I
statement
can't
of
take
young-
up, I can't presume that.
Young boys, then.
Mr.
he
Goswami,
named.
show me the law that whether I can draw a presumption here. I can't draw a presumption. The basis should be the evidence. There is
Why-
nothing.
Why, my lord, disregard the statement of the IO, my lord?
IO
Directly.
is not his own. It's only a reiteration of what was there in 161. But those three witnesses, even if we leave it,
So
there were other witnesses. They have also not said anything. No, but only on the basis of the IO's evidence can I hold him guilty.
Also, my lord, the statements of the others, with
Others are children. Then the few they don't even have any knowledge. They have heard about it. Hearsay. We'll examine.
Lordship may examine.
We'll examine.
Flash, my lord.
I'll examine your contention also. Okay. Mr. Alam, subject to further scrutiny, tentative view is this. Disposed of. List this matter before any other bench without me. This is against acquittal.
Lordship. Problem is that, Lordship, the sole respondent, the Bhagirath Balmiki was 2013, 60 years above old. That time, 2013, Lordship. The informant appellant may inform me whether the sole respondent or alive or not. Not, no, Lordship.
But
And
there is nothing here. The matter has been very well handled.
Lordship,
It's well written, the check.
Lordship. Check amount is only 95,000 Lordship.
Be that as it may. But the learned trial court has said this was basically a security check,
Security check.
and you have not proved the depth.
Lordship, that's right.
So what is there? What is left here? We'll dismiss it.
Lordship. I know, Lordship.
Your name?
K.R. Bora, Lordship.
A.R. Bora.
Lordship. Rightly passed, actually.
Hmm?
Rightly acquitted.
Rightly acquitted.
Acquitted. Highly obliged, Lordship.
That's the spirit. But you could have said this 10 years back. Mr. Rava, what is there? Huh?
Lordship, it is
Do you have a, Dayaldas has a tent house? Does he own a tent house?
ten house.
He has, Dayaldas.
Ten house.
Huh?
He was the owner was a ten house, yes.
No, Dayaldas, the accused.
Well,
Yeah,
that
yeah.
was his name. He is not. A non-existent person.
Respond, yeah, petition, appellant number 3, petition number 3. Does he have a penthouse? Materials were recovered from his house with the wording ATH.
Lordship.
No, that evidence has not been dislodged.
Oh, Lordship, mere recovery. Because he is innocent, he is unknown. Mere recovery does not indicate him to be.
Okay. Okay, make your submissions.
Learned Fair informed that my lord already 8 months. Gentlemen, I undergone.
6 months. Suspension the order. There's a appeal, my lord.
Hmm.
Appeal was also cancelled, my lord.
Hmm.
And order is, my lord,
So he has undergone imprisonment for?
Conviction.
So he has undergone the full 6 months.
Yeah, Lordship, the trial court gave conviction 6 months RI and fine of 500. And that was upheld by the first appellate court also.
So you have undergone imprisonment for 6 months already.
And not already because I have checked but could not find out the period, but they were in the jail.
How long?
That is why I could not find out the period.
Another court already, my lord, the earlier bail bond.
Bail bond is cancelled.
Cancelled, my lord. So,
And this court has not given any bail. We excuse him from the fine. What he has undergone, he has undergone to that extent. You are for the informant. Mr. Rabah, what you have undergone, you have undergone. No further imprisonment. You just check up once.
my lord.
You just check up and just put a small note with your hand. Disposed of.
Master Pass.
Here in this month. A Burua.
Yes, madam. You are for the informant. Has he paid the check amount? They have not paid the check amount. Dismissed. Ah. You are for Brahmaputra Ispat Steel. Who is appearing? Mr. Goel is appearing. A Goel. Just check up whether he is there. Maybe he has missed out. We'll take it up after some time.
It's your lordship. Lordship revision. A your lordship.
Anybody for the respond number 2? Nobody, na?
Lordship.
Gogo, you can be a bit more. Voice can go up. No problem.
Lordship. Probably that I need some time, your lordship.
Why?
Lordship. I'll go on the point of your lordship. He is government serving, your lordship. 498, your lordship. Other proceedings, your lordship. 1 5 draw against that your lordship in that.
But you have not taken that plea here.
Lordship, I have taken your lordship. Nine, your lordship. In round 9, your lordship.
No. Before the trial court.
I have taken your lordship. In the course part is there, your lordship.
It's there.
Yes, lordship.
What is he working as?
In railway, your lordship.
What happened in the 1 to 125 proceedings? No maintenance was given.
Actually, but later judgment, your lordship.
That will have no bearing here. That is just a prima facie thing. Here, show me.
Let me show. Lordship, the page number 13, your lordship.
Hmm.
7 number para, your lordship.
Hmm.
In course examination, stated that she has launched the 2 other case against the accused persons, and she had been receiving 2,500 as monthly maintenance. And lordship also admitted that her husband
Suggestion was made to her.
lordship, before that sentence, your lordship. She also admitted that her husband in the said 125 proceeding has stated that she is not his legal married wife, your lordship.
And the Amala Das wife, mother, evidence. PW4 Joyram Das. Deepak Das.
But no one is appeared their marriage, your lordship.
No, fine. Marriage need not be by attending the marriage. When you are staying as husband and wife, projecting it, that is also presumption can be drawn. Then
Anyway, lordship, I'm your lordship to prepare. Take some instruction, your lordship. Service, your lordship, 46.
maybe, let him be. We are not concerned. But if this is his conduct, better that he also suffers that. Heard the learned counsel for the petitioner. Also heard Ms. Bora, learned additional public prosecutor for this. Hearing remains inconclusive. Registry to list this matter. Pula dina dide. Undina pulibu. Vice. 22nd, 22/10/2025 for further hearing.
Lordship, 23rd? 23rd.
23rd for further hearing.
Public.
But that plea you will have to come with something very solid.
Yes, Lord.
Yes.
Please, Your Lordship.
Hmm.
Case of conviction under section 1 month under section 341 of the IPC, imprisonment for 6 months under section 323 of the IPC, and imprisonment for 1 year of the under section 324 of the IPC. That was upheld by the learned session judge, Lordships. There is a 6 cases in this case, Lordships. 3 are non-official, Lordships, and 3 are official, Lordships. The non-official witnesses are Lordship PW1 Lordship is the victim himself, Lordship, and PW2 Lordship is the brother of the victim, Lordship, and PW3 Lordship is the wife of the victim, Lordship.
Hmm.
And there is no any independent witness, Lordship.
Hmm.
And PW Four lordship is a doctor
The
lordship.
victim itself is a witness. Victim itself is a
Very-
witness.
very-
Hmm.
That's true, lordship. And lordships are PW4 is the doctor lordship who has examined the victim lordship, and PW5 lordship is the who has submitted search sheet lordship after 3 years of the incident occurred lordship, and PW6 lordship is the IO lordship. Now, your lordship may kindly see, may I read the FIR lordships? In violation of FIR lordships. May I read lordship?
Just a moment. Six months and 1 year. You have been behind the bus
No, lordship, I am on bail lordships.
all along.
11 years, last 11 years, I was on bail lordships.
Before that,
For that also, lordship, the Esconda search sheet was filed against me, lordship, and I have appeared before the. trial
you were
court,
never
lordship.
behind a bus.
No, no. There is so much content that there is, 164 as well as the FIR lordship.
Okay, where is the FIR?
FIR lordship,
Record.
record.
Okay, go to it.
I read the FIR lordship.
Yes.
Vernacular. এজাহাৰকাৰী বিনীত নিবেদন এই যে যোৱা ইংৰাজী 25/2/2010 তাৰিখে ৰাতি প্ৰায় 8মান বজাত মোৰ নিজা দোকানৰ পৰা ঘৰলৈ আহি থকা হাতীগড় আটকাই গাঁৱৰ মাজৰ পথৰ ওপৰত বাঁহৰ জেং গোটাই ৰাস্তা বন্ধ কৰি ৰাখি বাঁহ গছৰ আঁৰত উক্ত আছামী লুকাই থাকে। অধীনে মটৰচাইকেল ৰাখি বাঁহৰ জেংসমূহ আঁতৰাই পুনৰ মটৰচাইকেল ষ্টাৰ্ট দি পুনৰ মটৰচাইকেল ষ্টাৰ্ট দি ঘৰলৈ যাওঁ বুলি উঠোতেই উক্ত আছামীয়ে লুকাই থকা ঠাইৰ পৰা দৌৰি আহি হাতত এখন চোকা মিদ্দা লৈ আগফালৰ পৰা অধীনৰ মাথাত ঘাপ মাৰি দিয়ে, গুৰুতৰ জখম কৰে। তেতিয়া অধীনে মটৰচাইকেলৰ পৰা দাঁতিত বাগৰি পৰোঁ। মাটিত পৰি থকা অৱস্থাত পুনৰ বাওঁ হাতত বাউসীত মিদ্দাৰে গাদি মাৰে। তেতিয়া অধীনে মৰিলো বুলি চিঞৰ বাখৰ কৰাত উক্ত আছামীয়ে দৌৰি পলাই যায়। উক্ত আছামীক অধীনে মটৰচাইকেলৰ লাইটৰ পোহৰত দেখি সম্পূৰ্ণ চিনি পোৱা হয়। প্ৰকাশ থাকে যে চৰকাৰৰ 108 গাড়ীৰে চিলাপথাৰ চিকিৎসালয়ৰ পৰা আহি অধীনক ঘটনাস্থলীৰ পৰা 9 বজাত ধেমাজি অসামৰিক চিকিৎসালয়লৈ আনি চিকিৎসা কৰোৱা যায় আৰু অধীনে চিকিৎসালয়ত চিকিৎসাধীন হৈ থাকিব লগা হোৱাত গোচৰ দিয়া পলম হয়। This is the FIR lordship. And FIR was lodged in the 26/2010 lordship. 26/2010. Incident occurred in 25/2010 lordship.
So the next day the FIR was lodged.
Next day. Now I'm reading lordship as a PW1 deposition before the court lordship. আছামীক চিনি পাইছোঁ। মই আছামীৰ ওপৰত এটা গোচৰ দিওঁ। হাতীগড় আটকাই পথাৰ বাৰীত ঘটনা হয়। মই দোকান বন্ধ কৰি দাদা ভূপেন শইকীয়া, now he has added Bhupen Shaikia, is the border, no mention in the FIR lordship, no vehicle number, no person along with him mentioned in the FIR lordship. দোকান বন্ধ কৰি দাদা ভূপেন শইকীয়াৰ লগত মটৰচাইকেলত গৈ আছিলোঁ। তেতিয়া পথাৰৰ ৰাস্তাত এৰাবাৰী আছিলে। ৰাস্তাত বাঁহৰ জেং দম পাতি দি থৈছিলে। মটৰচাইকেল ৰখাই বাঁহৰ জেংজনী আঁতৰাই পুনৰ ষ্টাৰ্ট দিয়াত ৰাজীৱ বৰপাত্ৰই দৌৰি আহি মোৰ মূৰত ঘাপ দিয়ে। তাৰপিছত বাওঁ হাতত গাদি মাৰে। মোৰ দাদাই ধৰিবলৈ লোৱাত আছামী দৌৰ মাৰে। মোৰ ঘৰলৈ ফোন কৰোঁ 108 গাড়ীখনত আৰু ধেমাজিত ভৰ্তি কৰোৱাই চিকিৎসাৰ বাবে। মই ঘটনাৰ পিছদিনা থানাত এজাহাৰ দিওঁ। মই ধেমাজি চিভিল হস্পিটেলত 5 দিন চিকিৎসাৰ বাবে আছিলোঁ। He said that he is 5 days in civil hospital Dhemaji, and next day there is a contradictory in the statement lordship. পুলিচে মোক ঘটনা সম্পৰ্কে সোধপোছ কৰে। মই মূৰত বাওঁ হাতত জখম পাওঁ। 2008 চনৰ 30 ডিচেম্বৰত আছামীয়ে মোক আগতেও জখম কৰে। There is another case lordship against this.
What happened to this case?
Lordship?
Pending.
That they acquitted lordship. That case is acquitted by this person lordship. Now lordship the cross examination lordship. পুলিচে মই মটৰচাইকেল নম্বৰ দিয়া নাই কোনখন মটৰচাইকেলত উঠি গৈ আছিলোঁ সঁচা নহয় যে মই 161 CRPC ষ্টেটমেণ্টত দাদা মটৰচাইকেলত উঠি অহা কিংবা এজাহাৰ উক্ত কথাখিনি লিখা নাই in 161 statement he has never mentioned a motorcycle about lordship in his border lordship পথাৰৰ মাজত ঘটনা হয় সত্য নহয় যে মই এজাহাৰ দিয়া 161 CRPC ঘটনা পথাৰত হোৱা বুলি কোৱা নাই সত্য নহয় যে আগত দিয়া গোচৰত আসামীক শাস্তি নোপোৱাত পুনৰ মিছা গোচৰ আসামীৰ বিৰুদ্ধে দিছোঁ সত্য নহয় ঘটনা হোৱাৰ দিনা আসামী কেৰেলাত আছিলে সত্য নহয় আসামীয়ে কোনো মাৰপিট কৰা নাই this is the cross examination lordship now lordship PWD 2 his brother lordship ভূপেন শইকীয়া he stated in the lordship আসামীক চিনি পাইছোঁ গুচৰীয়া মোৰ ভাই হয় 2010 চনৰ ঘটনা দেউতা অসুখ বুলি গম পাই গুচৰীয়াও মই মটৰচাইকেলত উঠি গৈ থাকোঁতে ৰাতি 8টামান বজাত আটকাই নাহনি ৰাজগড়ৰ মাজৰ পথৰত তেতিয়া জেংবিলাক ৰাস্তাৰ পৰা আঁতৰাই থকা অৱস্থাত আসামীয়ে গুচৰীয়াক মিডদা এখনেৰে মূৰত মাৰি জখম কৰে পিছত আসামীয়ে পলাই যায় ঘৰত খবৰ দিওঁ 108 ঘৰ দিয়াত 108 খবৰ দিয়াত লৈ গৈ ধেমাজি চিভিল হস্পিটেলত ভৰ্তি কৰাই চিকিৎসা কৰে 2008 চনত একেই ঘটনা গুচৰীয়াৰ ওপৰত আসামীয়ে কৰিছিলে ক্ৰছ এক্সামিনেশ্যন লৈছে সত্য নহয় যে পুলিচক ভাইটি গুচৰীয়াৰ লগত একেলগে মটৰচাইকেলত উঠি যোৱা বুলি কোৱা নাই সত্য নহয় যে পুলিচৰ আগত মই ঘটনাৰ নিৰ্দিষ্ট জেগাৰ কথা কোৱা নাই সত্য নহয় যে মই পুলিচৰ আগত দাৰে গাড়ী মৰাৰ কথা কোৱা নাই সত্য নহয় যে পুলিচৰ আগত মই ঘটনা দেখাৰ কথা কোৱা নাই সত্য নহয় যে পুলিচৰ আগত মই ঘৰত জনোৱাৰ কথা কোৱা নাই সত্য নহয় যে মই ভাই বোৱাৰী ঘটনাস্থলীলৈ যোৱা নাই সত্য নহয় যে আসামীয়ে গুচৰীয়া আগুচি ধৰা নাইও কোনো মাৰপিট কৰা নাই সত্য নহয় যে পুৰণি আখেজত পুনৰ মিছা গোচৰ দিছোঁ আসামীৰ বিৰুদ্ধে Now, Lordship,
PW4 is nothing. Wife.
medical lordship.
Medical
Now, Lordship, your
also-
lordship, kindly say PW6 is IO lordship.
That's it.
IO. PW6 lordship. I did lordship. Mohan Bora lordship is IO. On 27 to 2010 তাৰিখে মই চিচিবগা আউটপোষ্টত IC হিচাপে আছিলোঁ গুচৰীয়া ৰঞ্জিত শইকীয়াই দিয়া এজাহাৰ পাই GD&T কৰা 389 dated 26 to 2010 চিচিবগা আউটপোষ্ট প্ৰাথমিক তদন্ত কৰা আৰু গোচৰটো ৰেজিষ্ট্ৰেশ্যন কৰিবলৈ চিলাফটা থানাত পঠাওঁ তদন্ত কালত গুচৰীয়া ঘৰলৈ যাওঁ সোধপোছ কৰোঁ স্কেচ মেপ অংকন কৰা জখমীক ধেমাজিলৈ লৈ আহে Now, I have stated that he has taken the victim in medical.
Read once again.
তদন্ত কালত গুচৰীয়া ঘৰলৈ যাওঁ সোধপোছ কৰোঁ স্কেচ মেপ অংকন কৰোঁ জখমীক ধেমাজিলৈ লৈ আহোঁ আৰু চিকিৎসাৰ বাবে ব্যৱস্থা কৰোঁ অন্য সাক্ষীবাদীক সোধপোছ কৰোঁ আসামীক তদন্তৰ সময়ত পোৱা নগ'ল পৰৱৰ্তী সময়ত মোৰ বদলি হোৱাত কেছ চেকত প্ৰভাৰী মহোদয় গতাই দিয়া হয় এক্সিবিট লৈছোঁ দিছ ইজ দ্য cross examination of the IO lordship kindly see গুচৰীয়াই মটৰচাইকেল চলাই গৈছে নে নাই
Just.
cross examination of the IO গুচৰীয়াই মটৰচাইকেল চলাই গৈছে নে নাই মটৰচাইকেলৰ নম্বৰ কিমান মই তদন্তৰ সময়ত তদন্ত কৰা নাই উক্ত বিষয় গুচৰীয়াই ঘটনাৰ সময়ত তেওঁ ককায়েকক লৈ গৈছিল বুলি মোক কোৱা নাই 161 CRPC মোৰ ষ্টেটমেণ্ট পথাৰৰ ঘটনা হোৱা বুলি কোৱা নাই মাত্ৰ মানুহ নথকা পথাৰেৰে যোৱা ৰাস্তাত ঘটনা হোৱা বুলি কয় PW2 ঘটনাৰ সময়ত মটৰচাইকেলত ৰঞ্জিত শইকীয়া গুচৰীয়া একেলগে অহা কথা কোৱা নাই মই স্কেচ মেপত জিআৰ কেছ বা এফআই উল্লেখ কৰা নাই মই স্কেচ মেপ আসামীৰ নাম উল্লেখ কৰা নাই মই স্কেচ মেপত আসামীৰ নাম উল্লেখ কৰা নাই স্কেচ মেপত চহী কৰা যদিও চিন উল্লেখ নাই স্কেচ মেপত ঘটনাৰ সময় তাৰিখ উল্লেখ কৰা নহ'ল ঘটনাস্থলীত ওচৰৰ এজনী শ্ৰীমতী সুনতি গগৈৰ ষ্টেটমেণ্ট মই সংগ্ৰহ কৰা নাই কাৰণ ষ্টেটমেণ্ট দিবলৈ অগ্ৰাহ্য কৰা নকৰা তাৰপিছত where the incident took place, there is a one house lawyer, one Suniti Gogoi, high statement also not recorded lawsuits. Even lawsuits, the IO has not visited, not recorded the statement of the accused wife lawsuits. Now the lawsuit, the accused has taken plea that he is in Kerala at the time of the incident took place lawsuits. But
What is the defense? Defense?
defense system,
Process do
I'm married to the defense system. Defense? Defense is the lawsuit, DW1 lawsuit, he's the accused lawsuit. যোৱা 25/2/2010 এনে তাৰিখে যিদিনা ঘটনা হৈছে বুলি মোৰ ওপৰত গোচৰ দিয়া হৈছে মই 2009 চনতে কেৰেলাত গৈছিলোঁ মোৰ বছৰ যোৱা বছৰ 2012 চনতে মই ঘৰলৈ আহোঁ there is a evidence judicial evidence lawsuit that he has came in 2012 lawsuit I have an order was passed by this honorable court lawsuit but that order was not placed by the engaged counsel lawsuit in the year 2009 lawsuit he has went to the Kerala lawsuit.
What was the occasion for this court to pass that order?
First lawsuit in the year 2008 lawsuit, this informant has filed a case against this petitioner lawsuit. Then he has went to the Kerala lawsuit. Now NBW was issued against the said accused person lawsuit in that case lawsuit, in 2008 case lawsuit. Now in 2012 lawsuit, he filed a criminal revision challenging that said NBW lawsuit issued against the accused person lawsuit, and this honorable court has interfered with the said NBW lawsuit.
At that time.
But the trial court has, this documents has probably not been produced before the trial court lawsuits. This is the exclusive evidence that he was in Kerala lawsuits. Charge was filed lawsuit in 2013 lawsuit. He was in the house lawsuit, but the IO has filed a further charge lawsuit. Now DW accused statement lawsuit. যোৱা 25/2/2010 ইংৰাজী তাৰিখে যিদিনা ঘটনা হৈছে বুলি মোৰ ওপৰত গোচৰ হৈছে মই 2009 চনতে কেৰেলাত গৈছিলোঁ মোৰ যোৱা বছৰ 2012 চনতে মই ঘৰলৈ আহোঁ কেৰেলাত মই আপেল কোম্পানীত চাকৰি কৰি আছিলোঁ আমাৰ কোম্পানীত মৌখিকভাৱে এপইণ্টমেণ্ট দিয়ে মই কেৰেলাত থকা প্ৰমাণ কৰিবলৈ মই নৱনীতা বৰপাত্ৰ গোহাঁই সাক্ষী হিচাপে আদালতত আনিছোঁ গোচৰ সংক্ৰান্তে যি ঘটনা ক'ব বুলি কৈছে মিছা ৰঞ্জিত শইকীয়াই মোৰ ওপৰত 2008 চনত এটা গোচৰ দিছিলে উক্ত গোচৰত মই আদালতত উপস্থিত আছিলোঁ বৰ্তমান উক্ত গোচৰটো শেষ হৈছে মোৰ গাড়ীৰ টিকট ট্ৰেইন টিকট অহা যোৱাৰ কোনো প্ৰমাণ নাই মই কেৰেলাত কাম কৰা কোনো আইডেণ্টিটি কাৰ্ড বা এপইণ্টমেণ্ট লেটাৰ বা কোম্পানী সম্পৰ্কীয় কাগজ পত্ৰ আদালতত দাখিল কৰা নাই ইনাকুলাম পালাম আদি জেগাত কাম কৰোঁ সত্য নহয় যে তদন্তৰ সময়ত মই পলাই যাওঁ কাৰণে তদন্তটো বিষয়ে পলাতক আসামী হিচাপে চাৰ্জশ্বিট দিয়ে সত্য নহয় যে ঘটনাৰ পৰা হাত সাৰিবলৈ মই মিছাকৈ আদালতত কেৰেলাত যোৱা বুলি কৈছোঁ
Then the next one, wife.
DW2 lawsuit. He's not wife lawsuit, he's sister-in-law lawsuit.
Sister-in-law.
আসামী মোৰ দেউৰ হয়
Devar.
ৰঞ্জিত শইকীয়াক চিনি পাওঁ গোচৰীয়া তাৰিখ আজিৰ পৰা 3 বছৰমান আগতে মই ঘৰত থাকোঁতেই ৰঞ্জিত শইকীয়াৰ মাত শুনো তেওঁ পথাৰৰ পৰা মাৰিলে বুলি চিঞৰি আহিছিলে উক্ত সময়ত 2009 চনৰ পৰাই কেৰেলাত আছিল আসামী অহা আজি এবছৰ হৈছে ঘৰলৈ সত্য নহয় যে মই আসামীয়ে ঘটনা কৰি কেৰেলালৈ পলাই সত্য নহয় যে আসামীয়ে ঘটনা কৰি কেৰেলালৈ পলাই সত্য নহয় যে ৰঞ্জিত শইকীয়াই আছামীক দেখা পাইছে, সত্য নহয় যে মোৰ দেউক বচাবলৈ মিছা সাক্ষী দিছো, পুলিচে তদন্তৰ সময়ত নোপোৱাত পলাতক দেখাই This is law.
Mr. Goswami,
Plus,
all said and done, this introduction of Bhupen Soikia, PW2, is not there in the 161 statement.
Oh, yes,
He is
Lord.
not there in the FIR.
Lord.
And the IO was examined on that point. He said there was no disclosure made. And the statement FIR, if we read properly, and the 161, if we read, he was alone going, he was attacked. Now seems that to give credence to that,
with that, my lord.
he has brought it.
Well, my lord, the incident is there.
Incident is there,
Yeah.
but this doubt,
That part only, my lord. Other.
because that's the evidence, that the evidence is of those two people only.
No independent evidence, Lordship.
Followed by evidence, my lord.
Caused by sharp cut object and
Yes.
caused by blunt object. But how this injury occasioned?
But the IO has not examined, Lordship, the driver of the 108, Lordship. He has stated that, Lordship, 108 vehicle was called, Lordship.
How will the 108 know?
Was examined on the same day.
And the thing is, the order of this court,
Yes,
there is a reference that he is in Kerala from 2009 till
that
2012.
is, my lord, not
No,
before.
but his evidence is there.
Prior to this,
His evidence,
Evidence as a DW1, my lord.
one, but
that
in the
is-
cross also he has put this issue.
On that.
That we are not
document,
taking.
Because, my lord,
But
this
in
is
the
a
cross also, that alibi, it's not that only in his evidence he has come and said. In the cross also, he has put this question.
Good, my lord. Implicate some other person, implicate another person.
That cannot happen. That
Yes,
normally
that
does not
cannot-
happen.
No, that is what there are certain decisions. Once, my lord, he is the eyewitness and also the injured witness. And injured, my lord, sterling witness, my lord, high pedestal, my lord.
Your name?
Rajiv Bopatra Goyal. Please, Lordship.
Yeah.
T. Sutia,
Please, Lordship.
then Junior, Torun Sutia. What is your first name?
Upon, Lordship.
Upon, then it's okay. Otherwise, we would have to distinguish. In the earlier case, you were acquitted.
Acquitted, Lordship.
And you were on bail all along.
Okay.
Okay. Disposed of.
Now, obliged, Lordship. Obliged.
No imprisonment, huh?
This is court, my lord. Trial court,
Ah,
present before the court, no. Right, my lord.
oh, they were already outside.
Right, my lord, and file this.
Item number?
41, my lord. I flag mark this, all this.
No imprisonment now. We'll find out some way. But we can't say that for the term already for imprisonment because he was never behind bars. He was never behind bars. Mr. Goswami, kindly go through this and find out whether he was under detention at any point of time. Item number 41.
I flag mark.
Ah, Shama, he's coming.
I flag mark there's all this.
Shama, নোটটা লিখে দিব দিছিল recently. Okay.
Wait, please. Lord. John, my lord, against the judge. Sir, my lord, he was 3 months, my lord. And we have taken the ground, my lord, that my lord, in law. Evidence of
What about the offering of money to
that
the
is-
victim girl?
That is already there, my lord. They have called the electrician to the electrical work. That is admitted by them. And the amount due was 3,000.
Have you been behind bars at any point of time?
Arrested, my lord, at that point of time.
How long were you behind bars? Go through the LCM. Otherwise, it's a conviction cannot be.
Hence of, my lord, the prosecuting.
PW3.
Yes. Addiction, my lord. She says, my lord, is not trustworthy, my lord. Therefore, he could not prove. That is the thing, my lord, that they have called me for doing the electrical work. They admitted, my lord. They have not paid the electrical amount.
By that time, you did something.
Oh, no. They said that
That evidence speaks. PW3 speaks.
PW, my lord. I will read from page 12, my lord.
Okay, what is the medical evidence with regard to the scratch injury? It is done?
Not support.
Huh? Not supported. The CPW3 statement is enough.
Medical evidence is not supported.
Minor discrepancies like
Minor, my lord. That is the thing, my lord. They
Climate
lost
base of
2
offering.
FIR.
these are very,
Huh.
the very fact. He has been
And she is a minor, 13 to 14 years. Yes. When was the incident? Date?
Incident took place, my lord, on
2508.
25/8/2009, my lord. The FIR lost after 2 days, my lord. Without any explanation, it was lost. In fact, my lord,
16 years.
2 FIR has been shown, my lord. That is the thing, my lord.
Conviction upheld. No imprisonment. Three months. Probation.
Nearby locality people.
Probation of offenders. No one. Can't do much better here. Disposed of. But the orders you will get only after Diwali. Yes, madam. You want to do the matter after having something, or you can raise your voice? Huh? Then raise your voice.
Convicted under 406 of IP. Punishment in for 3 months and pay rupees 2,000. On student.
Hmm.
Come to page number 10, Lords.
Hmm. Yes, go ahead.
Or that the under section 4 without considering the statement the accused by the complainant, the accused petitioner's house as Stridhan are still remain in the house of the accused. Complainant mentioned several articles in the list were not brought to the house of accused by the complainant. Are not available or not house of the accused. All the articles are remain intact at the house of the whatever the articles.
Yes, Bora.
by
406, 498 not proved. Criminal breach of trust with regard to that Stridhan property. How? Huh? Okay, complaint case. Okay. Enough for my assistance. Divorce not happened. Divorce has not taken place.
are living separately.
Had you filed any application before the CJM for return of the wife had filed any application for return of the Stridhan amount? No. What is the conclusion of the learned trial court? Okay, you argue your matter.
Actually, I am ready to give all the items whenever seek not items to her a ticket. Even today, Lordship. Is that your conditions?
Mr. Chaudhary. Mr. Chaudhary. One assistance. This was a case of torture, 498A. And the case was that the husband had driven away the wife because of the dowry demand was not met. Fine. She went away. Then the cases were lodged. And the court finally comes to a conclusion that 498A is not established. Not established. But it convicts the petitioner, accused husband, under 406, saying that while sending her away, the Stridhan was not being allowed to taken by her. She could have filed an application for that. For that occasion, this was a case only of 498A, not the other.
Also not there for 406.
406, subsequently, I think it was added. No, there was a case of 406 made out. Whether 498 not being established, 406 can be said to be established because there are ways and means by which she can get that thing back.
Right to the CGM.
CJM and again got a thing. So 406 here, would the conviction be proper? I don't think so. Right? Yes, madam, what do you say? Thank you, Mr. Chaudhary. Huh?
All the articles
Okay.
is ready.
Allowed. I'll do that. I'll do that. Your name, madam?
K Begum.
Hmm?
K Begum.
Mr. M. Ho. Yes.
Please, your lordship. For a petitioner, my lordship.
This is not the way you withdraw the wakalatnama.
Past 10 years. Similar nature case was same parties, and another case for filing revision. Yeah, when I had contact in 2015, then they had not contacted.
No, this is not the way you withdraw your wakalatnama. You walk up to the court and say, I'm withdrawing. That is not the way. Send a notice. We'll say that you are not there. This is a revision petition. We don't require you. We don't require you. We'll say none has appeared today.
Obligation.
Your name?
Yes, Rai, my lordship.
Hmm?
Yes, Rai, my lordship.
C.S. Rai.
Along with all colleagues, my lordship.
You cannot withdraw in this manner, Mr. Rai.
I understand, my
You will have to send a notice.
I will send.
Get that then. But today, 14 matter, we'll say you are not appearing. You said you are not appearing. And where is madam? There was. Madam, we'll call it once more because the respondent is representative.
Here, my lord, there is some doubt, my lord. Acquittal regarding
Hmm. It is stated at the bar that the judgment was conviction under
Against acquittal, lordship.
above stated at the bar that the present appeal has been instituted against the judgment and order of the trial against the order passed by the trial court acquitting the accused acquitting the present respondent number 2 from the charge framed against him under section 302/201 IPC. It is stated that the present matter is required to be considered by the division bench of this court. Also, in view of the above, registry to examine the matter and list the present appeal before the appropriate bench.
Pleasure, lordship.
302, if it is an acquittal, then it will be before, because if it turns into a conviction, I cannot do it. It will have to be by the,
up to 10, if it is convicted,
then also I can do it.
Then, but more than.
More than 10, then
Acquittal
it has to,
cannot
because
be-
it's acquittal, it can be 302 or it can be an
Division.
acquittal per se. Yes, right.
That is.
Pleasure, lordship.
I plead the lordship.
Yes, Mr. Day.
My lord,
It is Joakali matter. No?
incident took place, my lord, in this case, 31/2005. My lord, FIR was lodged on the same day. after about few hours, my lord. Accordingly, such that FIR was registered, my lord, under section 342, 307, 34 IPC. Subsequently, my lord, charge sheet was submitted on 27/4/2005. And adding more section, my lord, that is 498A, 307, 34 IPC. Well, earlier in the main FIR, my lord, there is no section 498A. It was subsequently added, my lord.
But the ingredients were there.
My lord, kindly see the FIR, my lord.
Let us see 498A first.
My lord, in the FIR, kindly see the FIR, my lord. The Assamese version, my lord.
It is in the records. You go through.
সন্মান সহকাৰে আপোনাক জনাও যে আজি ইংৰাজী 30/1/2005 তাৰিখে ৰাতি 12:30 মান বজাত উক্ত আসামীগণৰ ঘৰতে মোৰ ছোৱালীৰ পাৰবিনা বেগমক ঘৰৰ ভিতৰত আবদ্ধ কৰি প্ৰাণে হত্যাৰ কৰিবৰ উদ্দেশ্যে আসামীগণে মোৰ ছোৱালীৰ গাত কেৰোচিন তেল ঢালি জুই লগাই দিয়ে, ফলত তাই বৰ্তমান গুৰুতৰ জখমী অৱস্থাত সংকটজনক হৈ আছে। গতিকে মহোদয় তদন্তক্ৰমে ব্যৱস্থা লোৱাৰ বাবে অনুৰোধ জনালো। My lord, here the confinement and my lord, that try to attempt to murder, my lord. This is the allegation, and accordingly, that FIR was registered under section 342, 307, 34 IPC.
Registered under section?
Under section 342, there is a confinement, my lord, wrongful confinement, and 307, attempt to murder, and 34 IPC, my lord. And
It
they have
was subsequently added when?
my lord,
498A was subsequently added.
subsequently added, but in the start sheet, my lord. When the submitted charge sheet, it was added, my lord. That is on 27/4/2005.
Now in the charge was laid under which sections?
That was framed under section, my lord, 498A,
34.
307, and 34. Cruelty by husband, attempt to murder, 34.
Okay. So what is the error? If the police during investigation had found commission of an offense under 498A also, a charge has been laid against that. Cannot be held to be.
Now, my lord, there are 6 witnesses examined by the prosecution side, and 1 witness from the defense side, my lord. In the PW1, my lord, he has stated PW1,
Anwara Begum.
Anwara
Mother.
Begum, mother of the victim, my lord. Petition number 1, Anwara Begum is the mother of the victim. Petition number 3, Parvina
Is the victim.
Khatun is the victim. And PW4, Muhammad Kutubuddin is the father of the victim. My lord, PW1, in her evidence, she stated that her daughter was married, love married with the accused Jamaluddin, and they went to Dimapur. And they was there for 9 months. And there was no conflict between them. And when they came to their native place at Kosua, Rangolo Basti, evidence of PW1, may I give a translated copy, my lord?
No, fine, you read the. You have a translated copy with you?
Yes, my lord.
Give me. Or you can read the vernacular, no problem.
My lord, it is very difficult to make this. But I was,
You can give a copy to madam also. Hmm.
PW1, my lord. Page 2, cross-examination.
But let's see the chief wherein she says about the demand of dowry.
Demand of dowry, my lord, is in chief, my lord, he stated
That she paid, there was a demand and 10,000, 5,000, 5,000 to
5,000 was paid. But when the demand was made, when the 5,000 installment has been paid, and to whom, where it is not mentioned, my lord.
Okay.
There is totally silent, my lord. It is then just says that they demanded so and so, I have paid so and so. And my lord, in cross-examination, last portion of page 2, my lord, PW1 evidence. Last 3 lines, my lord, page 2. At the time of incident, Jamal had 2 children from his first wife. There are 2 wives, my lord. Jamaluddin has 2 wives. This is the Parvina was the second wife. This is the my lord most.
That is an admitted fact.
Admitted fact.
And
No
this
dispute on that.
this is the only dispute, my lord, subsequently I'm coming. This is the problem, my lord. At the time of incident, Jamal had 2 children from his first wife. During their stay at Dimapur, there had no trouble between the two. And next page, my lord, page 3, Jamaluddin built a separate room for my daughter. So, my lord, from this version, from the mother's version, that the relation between the Jamaluddin and our daughter, victim, was quite normal, my lord.
Not normal in that period, normal in Dimapur.
Dimapur. But no, here it is separate room. It is in the native village.
Native
Rangoli.
village, separate room, but the
Separate room has been made
demand
out for her.
she-
And
during the, she's specific, during the stay in Dimapur, there has been no trouble between the two.
Two.
Okay, now come to the.
And the husband has also built a room for his
Fine.
wife. Then incident took place on, my lord, at about, that is on long back, that is after about 2 years of marriage, my lord, 31/2005.
But within that 7 years range.
7 years, within 7 years, my lord.
Huh? Huh.
Cruelty, whether there is cruelty
You
or
just go ahead, Mr. Devde.
Going, my lord, on the incident, date of incident, my lord, when she raised halla, hue and cry.
Say, Mr. Day, there are 2 aspects here.
Yes.
One is 498A and the burning. 307. So, with regard to the 498A, there has to be a demand for dowry, which was not paid, leading to torture. So, here, what we see is
Torture, my lord, whether it is a continuous torture from which date it was started.
okay, fine.
Is
That
there
is your
anything-
submission. That is your submission.
My lord.
We'll record it.
My lord.
But generally, there has to be a sequence of events which shows the torture because of non-fulfillment of this demand. As far as PW2 is concerned, she is not an eyewitness to the 307. She at best is a witness with regard to 498A. So here the evidence is that there was a demand and there was a torture. Now let us see what is the
My lord,
further materials.
as per the PW1, my lord, when there are 200 to 300 people were gathered, my lord, when the incident took place and hearing hue and cry.
Because
gathered.
they went subsequently.
Yes,
Okay.
subsequently.
Now you read.
But, my lord,
My daughter
Specific-
told me that Jamaluddin had set her on fire.
fire. See, my daughter, my daughter told him, but, my lord, she has not seen, but it is told by her daughter.
It is not
You
true
women
that
also.
now you come to the next paragraph,
Now-
1, 2, 3, 4. In my statement, I did not say
Well,
that they were.
Before that, my lord, kindly see the second paragraph from last, bottom, from bottom. It is not true. Neither Jamal nor his family members had never sent my daughter to our house to take money. I had informed Mojibur, Moinuddin and Asakur Ali about these things. My lord, none of these persons has been examined. These are the, if the things is told, demanded, that the husband demanded so and so in front of them, my lord, Mojibur, Moinuddin, Asghar Ali, none of them is
No, she said that I informed. When we have the main witness before the court, why do the other repetitive evidences is to be taken? Hearsay evidences. We
My
have the direct evidence here.
direct evidence, my lord, when, how it is paid, when it is paid, it is not there.
No. You say about Mojibur, Moinuddin.
My lord, these are the informed
Persons informed. They are.
paid.
We have the
They-
direct evidence before the ladies before the court.
My lord, may I-
From whom the things have emanated? Who knows it? Who can perceive it?
my lord, who
Evidence
says
act-
only 3 persons says, mother, father and daughter.
Who else can say? Public will not come
But
and say
they are
that there
all-
has been a
all the
demand of
family
delivery.
members, they are projected to punish the husband.
It can only be these people only.
My lord, there is no witness, there is no eyewitness that the husband has caused the incident.
Okay, next one. This is done.
My lord,
Hmm.
my lord, my submission is that
Okay,
if,
now you go only
My lord.
one. There are other witnesses.
my lord,
Hmm.
PW2, my lord,
Hmm.
PW2 he declared as my lord
Hostile.
hostile. But in cross-examination, my lord, in the cross-examination by defense, my lord, page 6, he stated, on my arrival, I found a lamp on the bed and lying some at my lord, there is inside the room. I did not see fire on the bed sheet. Police recorded my statement. My wife arrived within minutes of my reaching there. When asked how he had caught fire, my daughter did not say anything specially. Instead, he merely said that there had a fire and that she would not survive. I have cordial relation with Parvina's father. He never told us about the accused person committing physical assault on Parvina. My lord,
Now read that. It is not true that in my statement, just after the.
my lord, in chief, PW2, in chief, he stated that.
No, not chief. After being declared hostile,
Hostile, my lord.
just read that statement, page 6.
Now, my
It is
lord,
not true that in my statement to the police, I said that having gone to so-and-so, when I had gone into Parvina's, I saw Jamaluddin, so-and-so, take so-and-so. And a number of people that they had been trying to, Kutabuddin immediately fetched so-and-so and had taken, I suspected that since Jamaluddin had asked Parvina to bring 1 lakh, and since Parvina had failed to comply with that direction, so Jamaluddin Asif Nurul had said. So this part of the statement adds support to the father-mother victim, 498A.
suspect.
Okay.
No, my lord, here, Jamaluddin, he also, my lord, PW2 also stated that there was person, I saw Jamaluddin Asif Ali and Nurul Islam take Parvina out of the room to leave.
Okay, fine,
And
that will
My
come.
lord, that persons were also not examined, my lord. These are all independent witness, my lord. The independent witness not
Now, PW3, the victim.
PW3, my lord. PW3, my lord. He in chief, it is, my lord, I am reading her evidence. My father's name is Kutubuddin Ahmed. His house is at Rangoli Basti. Today I have come from my father's house. My husband Jamaluddin is an accused in this case. My marriage with him had taken place 4 years ago. After my marriage, I lived with Jamaluddin for 2 years. His house is at Rangoli Basti. 6 months after my marriage, my co-wife fetched rupees 1 lakh from her father's house and gave it to my husband. My lord, this is also not proved whether second wife has given 1 lakh rupees to her husband or not.
Where is that?
This is a statement.
There is
It's
no.
a mere statement, my lord.
There is no cross to that effect, Mr. Day.
My lord, I am coming. The cross examination, I am coming. Then husband told me that should likewise rupees 1 lakhs from my father's house and give. This is the, my lord, already stated his mother. Now, my lord, the incident, how she explained in page 9. When I failed to bring him a sum of rupees 1 lakh as demanded by him, my husband, father-in-law, Nurul Haq, and co-wife Manavi Minabai physically assaulted me around 12 midnight on 31/2005 when I was still in my husband's room. They assaulted me with their hands, lathis. Father-in-law and my co-wife held me backside the room while husband tried to pour kerosene oil on my head. As I pushed him, the oil fell on my neck and on the lower side of both my elbows. After pouring kerosene, my husband struck a match, set fire on. When I cried out, people come, Shahabuddin, Khalil, Jolil. Well, these are the names she stated, but none of the persons has been examined, my lord. And a lot of other people came. While I was shouting and was in distorted state. I was wearing cotton sari, petticoat, blouse, and the hands. So people come to look me hospital. When I was in father's custody, Khalil, Jolil, a number of women extinguished fire. My lord, these are the persons who are involved at the time of incident, just after the incident, my lord. After hearing, they came on the spot, but they were not examined, my lord. Independent witness, my lord. Only one independent witness, that is PW6. Only there, but other witnesses are not examined. So it is, my lord, there is clear doubt regarding the veracity of the statements of PW6. My lord, in cross-examination, my lord, she stated, page 10, paragraph 3. Paragraph 3, my lord. The incident took place in the house newly built by my husband. I had spent only couple of days in that house. Husband had lived with me in the said house on the night just before the day of incident. It is not true that on the day of incident I had gone to my father's house. My husband lived with co-wife as well. So, my lord, he stated that newly constructed house they lived with her husband even the day before of the incident, my lord. And then, my lord, in suggestion, she stated paragraph, page 11, second paragraph from bottom. It is true. It is not true that my statements that my husband, co-wife, and father-in-law had asked me to bring 1 lakhs from my father's house, and that when I had failed to bring them the money as demanded, they had set me ablaze, are false. That means, my lord, she admits that not only the husband but his wife and father-in-law also demanded money. Earlier, PW1 says his husband only demanded money. Now she said not only husband but her father-in-law and co-wife also demanded money. So there is, my lord, contradiction between evidence of PW1 and PW3. And moreover, my lord,
Ms. Bor-
father-in-law,
Go through the evidence of with regard to, there are two aspects, 498A. 498A seems to be established. What do you say about the 307?
I'm just relying on evidence of PW.
Hmm.
That aspect, lordships, to be very.
PW?
PW6.
He has seen. Not seen. That set. I read his statement, lordship.
Just a moment. Hmm.
At home. In her person.
No,
The
this is
statement
the one that is creating problem. The last line. The door was closed
were closed.
from inside.
Inside.
That is attractive. But 307, there is a doubt.
That's,
Because if it is locked
yes.
from bolted from inside,
Yeah.
then Jamaluddin cannot be there. Because there are other evidences which says that after the door was opened, Jamaluddin had come out from the room of his first wife. So there is a doubt created.
Sit down.
My lord,
I read the.
You just take out the vernacular. This part of the vernacular.
Lordship.
PW6,
I'm-
second paragraph onwards.
Yes.
Hmm, hmm.
Division of my senior.
Peleg.
Peleg
Peleg
Dameron
Dameron.
Mauritius.
Asim.
So that the fact that
Right,
the room and there was not, her husband was not there. So a doubt is
out is.
created.
And from. Good. Well proved, that's.
498A proof. How long have you been behind bars?
My lord, almost 180 days, my lord. Almost. Out, my lord. My lord, in this regard, my lord, regarding 498A, I was, my lord, only the interested witnesses of the family. Only
Show
their
me a
version,
decision.
Huh?
Show me a decision of the Honorable
My-
Supreme Court in that line.
my lord,
That the interested witnesses ought not to be relied upon.
my lord, my lord. That is, my lord, one, it is there. Minal Kanti.
There is a difference between.
Because we can't expect any other witnesses to be present there. No. With regard to the demand for dowry, it will be within the family unit.
Family lordship.
Yes, which is the
My lord. Paragraph 63, my lord.
decision of our High Court.
This is our, my lord, not Agartala bench, my lord.
63.
2010 GLR 445. Minal Kanti Roy Borman versus my lord. Even if the aforesaid statement of prosecution with received, then also question remains when the accused appellant number 1 demanded money and how and in what manner he tortured the deceased and harassed her as alleged, and there is also no statement which can prove that it was a case of repeated and continuous demand of money by the appellant number 1. For establishing a case under Section 498A IPC, the cruelty must be of such a nature as it likely to force the woman to commit suicide or to cause grave life, limb or health, whether physical or mental or physical, of the required to be proved. Mere omnibus statement regarding demand of money does not ipso facto make out a case under Section 498A IPC. Prosecution is required to prove the over acts contributed by the accused appellants beyond all reasonable doubt as per the views of the apex court in Shukaram and another Supra. Then, my lord, in paragraph 64 is stated, my lord, in page 490, paragraph 64, the middle of the, my lord, paragraph, I am just reading, my lord, relevant portion. Testimony of father, mother, brother, and other close relations of the victim cannot always be treated reliable as they are highly interested party with an intention to punish the husband of the victim as well as the members of the family in-laws. So, my lord, always is the presumption that,
Read further.
my lord, there is no doubt that there are some cases where even on the basis of the testimony of the father, mother, brother, and other members of the family of the victim in a case of section 498A and 306 IPC, conviction can be made subject to the statements are based on direct evidence or facts relating to cruelty, abatement, and or investigation relating to demand of dowry and cruelty, and such cruelty driven the victim to commit suicide. But in the instant case, admittedly, there is no direct statement and or evidence against the accused appellant. Number one, that he asked for any unlawful demand of money by as urged by Mr. So and so, learned counsel. Accordingly, this court, the submission of Mr. So and so has also force as same is based on the material available on record. Hence, this court is unable to accept the submission of as it is settled by this time that every harassment by the husband or in-laws to the victim, wife and daughter-in-law are not come within the meaning of cruelty to establish that there was an cruelty on the part of the family members of the victim. Prosecution is to be established that such harassment is for the purpose of mental and physical torture towards the victim with an intention to fulfill the unlawful demands of the husband and the family members of the in-laws of the victim. As the facts from which cruelty is to be inferred are to be alleged and proved, it is not sufficient to merely say that the deceased was subjected to torture or cruelty. Specific acts of commission or omission or commission by the alleged offender has to be specifically proved. In absence of proof of such an acts of omission or commission, the court is not in a position to decide whether conduct of the accused amounts to cruelty within the meaning of 498A. So, the vague and exaggerated statements that the deceased was subjected to torture or cruelty is not enough to prove the charge under section 498.
I got it, Mr.
My lord.
Anything more?
My lord. Another judgment, my lord. Imran Khan, my lord, that is 2015 to GLT.
Page?
Page, my lord, 893. 2015 to GLT 893. Imran Khan versus State of Assam. Paragraph, my lord, 810. And it is also starts from paragraph 5, my lord. Paragraph 5 also there. Paragraph 5, my lord, is there. Paragraph 5, my lord.
Jitendra Som was.
My lord.
Then you want me to go to?
Paragraph 8. Is referring, my lord, Giridhar Shankar Tawarde versus State of Maharashtra, 2002 5 SCC. Held, my lord.
Okay, then.
Fine. As the facts from which cruelty is to be inferred are to be alleged and proved.
I got your point.
My lord.
I got your point.
And another point, my lord, that is that portion, my lord, already 407, 307, it is kerosene because it is not proved.
Cannot be held to be.
My lord.
Yes, madam.
was
No, madam, I'm coming to that. You say PW3 is the star witness.
statements corroborated by the
Corroborated by PW1, PW2. 3 is there,
PW4,
4.
PW,
Doctor's evidence is with regard to the burn
sorry, lordship.
injury.
Out
So
of-
307,
Out of that
uh,
lordship, physical, she has been
that's what I'm saying.
of illegal.
Madam, means if this has to come into being, 498A, forget 307, 498A. Subject such woman to cruelty shall be punished with imprisonment. Cruelty has been defined. Any willful conduct which is of such nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to her life. So and so, so and so, so and so. So here the evidences that have come on record, demand is there, but the torture part is only this incident. Before that, there is no incident highlighted. Right? So this incident, if it is part A, then it has to be a suicide attempt, which is not established, or it has to be 3 circumstances: accident, suicide, or attempt to murder by the husband. So the court below went that it was attempt to murder. So 498A demand was held to be satisfied and 307 punishment was given. Here in the matter, there is demand. And the incident, which can be B,
Yes, that can be B.
is only that incident which occasioned in the room of the wife. And we don't find the husband there. So that is in dark. So the 498A cruelty part is not established. The harassment of the woman where such is with a view to cause. So that harassment that is there, that is one that happened within the room. Room, the husband is not there. Room was bolted. So if the room was bolted, where is the, it's only an accident. So now you
Zero part is
cannot,
there, yes.
that part is not proved. Allowed. Mr. Day, don't mind my asking questions. I'm also trying to understand this law.
Okay.
এনা সৰু সৰু অৰ্ডাৰ হ'ব, বেছি চিন্তা কৰিব একেলগে দি দিম। এটা লৈ ল'ব সেইটো।
P3.
Mr. C.S. Ray,
Yes, sir.
Learned Counsel for the petitioner. Heard Mr. C.S. Ray, Learned Counsel for the petitioner. Also heard Miss N. Chaudhary, Learned Counsel appearing for the respondent. Also, Mr. C.S. Ray, Learned Counsel at the outset has submitted that he would not be further appearing in the matter. Full stop. Accordingly, the matter was heard on merits. Accordingly, Ms. S. Chaudhary was heard. So this court has also considered the materials available on record. Full stop. On such full stop. The present appeal, huh? Ehini, enaka, arambogun, ehini khali marikini at page ata. We are disposing it off. We are allowing, we are dismissing the appeal.
Obligation.
Mr. Kejriwal, you're waiting. The other side is there. Is available. We'll have it at 2. Uta was at item number 52 to multiply. Please inform Mr. Muzumdar. Mr. Chaudhary, yes.
Admit it and can be fixed.
No, it's 14 matter. We are taking it up for disposal. Today itself. We'll have it. Just have 5 minutes with Mr. Hazarika and then Mr. Kejriwal and then come back to you. We are taking it up. 14, no admission. You want today?
Tomorrow, Your Lordship.
No, make a mention. Tomorrow, Paribozanu. No, it will be difficult tomorrow. Have it on the reopening. 22nd.
Obligation.
Because they have already prepared a list. Now, if we put this in again, they'll have to prepare another one. So, give it 22nd withdrawal only. Where is Mr. Mr. Kejriwal, let us not trouble ourselves with this matter. We'll have it immediately after the Diwalis so that we give some time.
First week, I will be out.
Okay, you give me a date. As agreed to by the Learned Council for the parties registered to list this matter again on. You have a date from, confirm it from Mr. Mojumdar.
6 November.
6 November. A very auspicious day for me. 6 November 2025. 6/11/2025. But you confirm. After 6th, you are here.
I'm here.
Let's see with Mr. Mojumdar. He may have some bags coming from some places, so he may have to pack up and move. We don't know. Mr. Mojumdar may have a bag may be coming from somewhere. Cloth bag, not other bag. Just confirm and tell her.
Thereafter, in November, my lord, I will be out during.
Oh, now we don't find you both in Guwahati. You are out only.
Lord, we are shifting. Frankly speaking, next year we will shift from here.
We'll not permit that. There will be a restraint order from this court.
Like.
This is a revision, Lordship, where conviction is under section 324 for 6 months. Pay fine of rupees 2,000.
The tea garden waiting from the backside.
Yes.
Incident is of 2012.
25/8/2012.
13 years. Yes, material are there.
That ground is that conviction is based on the evidence of the victim.
Naturally, he is
Yes,
the
yes.
best one.
Yes, Lordship, but
And that victim with evidence was not dislodged. And that aspect, I think, was taken care of by the appellate court. You had raised this point. The appellate court had discussed somewhere. And that injury is also corroborated by the medical evidence. 6 months. 324. Right?
yes, sir.
Conviction upheld. Probation. After 13 years, why 6 months we send him back to jail? Jail is for better people. You'll get the orders only by after Diwali. 40?
8.
Yes, Chaudhary sir. What's to IC to? Can copy to IC. Yes, what is the ground? As you wish.
There is a page
How
judgment.
long will you take? Oh, then it's fine, because I have another bench at 3:30.
For that, my lord, it will be.
This is item number 48. Yes, Mr. Chaudhary, you can start.
Come to page 11.
Hmm.
Lecture 1.
Hmm.
This is the complaint petition.
Hmm.
Complainant is Zamiruddin and accused persons are Abu Samad Chaudhary and Imdadullah. Both are, one is the president, accused number 2 is the secretary of one, my lord, NGO. NGO. So, my lord, may come to the next page. A small complaint, my lord, 2 pages complaint. I'm just reading out.
No, you can give me a control. You can give me a.
Directly, your lordship then can come to para
1 lakh rupees was given.
para 6, my lord.
Ah. Hmm.
This is the important part.
Hmm.
That it is to be mentioned here that after taking the debt of above referred 1 lakh rupees, the accused persons jointly in their official capacity took various amounts from time to time from the complainant for their further official functioning, such as once the accused persons took an amount of rupees 20,000, once 5,000, once 15,000, and once 50,000 from the complainant, and all the amounts were returned by them through checks in different times. Lord, this line is very important. By obtaining the acknowledged signatures of the complainant in the payment vouchers maintained by the accused persons. Once with a profit of 2,000, with the amount 20,000, but the check of rupees 1 lakh referred above has been returned unpaid twice. So, may at this stage, I'm just showing if your lordship takes up the evidence. Evidence. Lordship will find initial deposition of the complainant. I am having one handwritten deposition affidavit. I'm also having a certified copy of that, my lord, if your lordship requests.
Affidavit is 8/9/2010. Zamiruddin.
My lord, Zamiruddin's affidavit.
And the order is 1910.
But at paragraph 8, if your lordship finds, my lord, the same statement, the said affidavit, this is not affidavit evidence, my lord. I'm just pointing out the initial deposition that is filed with the complaint. There he said the same thing, the version was same, that by obtaining the acknowledged signatures and payment vouchers maintained by the accused persons. That statement is very well there. Then similar statement your lordship will find in his evidence in chief on affidavit, SPW1, at para 7. Similar statement that he put his signature on the return vouchers.
Read it.
Paragraph 7 of the affidavit evidence that I want to mention here that the accused persons jointly in their official capacity borrowed various amounts from time to time from me for their official functioning. Once the accused persons borrowed an amount of rupees 20,000, once 5,000, once 15,000, and once 50,000 from me, and all the amounts were returned through checks issued by their issued in their official capacity in different times by obtaining acknowledged signatures of myself in the payment vouchers maintained by the accused persons. That is there.
So you mean to say that for this 1 lakh, there is no acknowledgement made?
There is acknowledgement. He has disputed his signature there. Just taking your lordship now for this signature portion, my lord. At page 22, my lord, of my complaint, even your lordship will find in the evidence exhibit portion, my lord, that is exhibit B series, B1 to B4. My lord will find these vouchers, and at the extreme left-hand side, over one revenue stamp, the signature of the accused complainant is there.
This is with regard to 22,000.
22,000. Now, next page, 23, this is
15,000.
with regard to 15,000. Now, next page, your lordship will find these two, B3 and B4. These are most important documents. B3 relates to the check of 1 lakh which has been bounced. Lordship will find 1 lakh amount in what's that big column, my lord. 1 lakh rupees only by check number so and so. This is the check number 002888 PNB Rupohiyat branch, Nagaon. So this was issued on this voucher is of 19/2/2009, and his signature is there. Now your lordship may kindly come to the next page. My lord may kindly have a look at this is dated 30/3/2009, 3/03/2009. What it says, my lord, loan return account against the agreement so and so, dated so and so, and bounce check number 002888.
Who is Jamiruddin is you?
Jamiruddin is the complainant.
Complainant, okay.
So Jamiruddin's signature is very much present there in this return voucher. And signatures are very much similar, my lord. My entire case is on that. Signatures were present in his
So you
entire
mean
complete
to say that there was no depth?
No, not at all. And I can prove it through one exhibit, my lord, and DW2. I'll come to that.
Okay, how did the learned trial court deal with this?
Trial court, my lord, only stated regarding 139, 118G
So-
assumptions. All
No,
those-
one thing. You have this voucher that you have produced.
My lord.
Let us take it on its face value.
Yes.
The money was paid. What happened to the check that was bounced?
The check was bounced twice. Before I paid the money, check was bounced by him. And after payment, the check was not returned to me.
Why?
Lord, that is why I said
Why
that
have you paid him the money without taking back the check?
My lord, I cannot say at this stage why he did not receive that check.
Because
But-
that will give rise to a doubt.
Yes. That doubt I will clarify. That doubt will be clarified.
One, once you receive the notice from the respondent here,
My lord, in
page
that,
15.
in that context, my lord, I am just trying to show your lordship, my lord, exhibit C, that is at Annexure 6, page 26. Exhibit C kindly have a look at this exhibit C, my lord.
Forget it. You come to page 15.
1-5. Yes,
This is the notice, maybe probably after the second bouncing.
yes,
Your reply, come
Well-
to page 18,
yes,
where you have said
yes,
that
yes, yes.
that amount is there.
I'm admitting it. My lord, just have a look at the date of this annexure 2 document.
No.
Date is
Here
yes.
you say that the amount has already been paid. There is no point in retaining the check, return the check. Page 17.
Page 17.
19/2/2009.
That is reply against the legal notice filed by the complainant. That is my reply, where one date is mentioned wrongly.
No, that is the one which is creating problem. So 19/2/2009, according to your statement also, it is only the giving of the check, not the money.
Very
Why
well.
this?
19/2 is wrongly mentioned in this.
No, it cannot be.
Because on 19/2 is the date
Huh.
when the amount was, when the check was received. By looking into the voucher, your lordship will find
19/2.
19/2.
So here the reference is to 19/2,
19/2.
not 33. It should have been 33.
Have been 33, but wrongly written as 19/2, because your lordship will find at the top of the notice, it is written as 19/2 when this check was received, and again the amount was paid on 19/2. This is a typing error. It cannot be 19/2.
Okay.
Well, before issuance of this legal notice and this reply, there is another notice that is on record, that is exhibited as Exhibit C
Where?
at page 26, Annexure 6. My lord, may kindly take up the date, 10/6/2009. And this legal notice was of 12/6/2009, and it was sent on 19/6. That will, your lordship will find that Annexure 2A, page 16. Although the notice was of 12/6/2009, but the same was sent on 19/6. Whereas this notice, Exhibit C notice, this is of 10/6/2009, but the same was sent on 18/6/2009. This is prior to sending of this legal notice. Exhibit C. It clearly says that I'm reading.
Okay, got it. How was this point dealt with?
Not been considered. There is no mention about Exhibit C. There is no mention about the fact that DW2, the author of this letter, he has entered into appearance. He he proved this document. Was examined as a witness, DW2. He proved this document. Nothing has been discussed in the judgment. Both
Okay.
the judgment.
Let us see the cross of Jamiruddin.
Yes. Now, the very relevant things at page 2 of the cross of Jamiruddin, your lordship will find after this exhibit A5,
signature of
Assami gonok beleg সময়ত মই টকা ধাৰত দিছিলো। এই টকাবিলাক অফিচিয়েল কেপাচিটিত তেওঁলোকে ৰিটাৰ্ণ কৰিছিল after taking my signature in payment voucher. Accused maintained a payment voucher book. Now, your lordship may kindly see. Exhibit B is payment voucher book. Exhibit B1 ত 22,000 টকা মই ৰিচিভ কৰিছো বুলি লিখা আছে, white check number so and so. Exhibit B1 ত মোৰ সহি নাই. Straightly he has denied his signature.
Sohi nai.
চহী নাই, ক'তোৱে নাই।
B2,
B2ত মোৰ চহী নাই, B3ত মোৰ চহী নাই, B4ত মোৰ চহী নাই।
read 1,00,000 টকা cash মই
1,00,000 টকা কেছ মই আছামী পোৱা নাই।
পোৱা নাই।
আছামীৰ পৰা পোৱা
পোৱা
নাই।
নাই।
2
লাখ
লাখ বাহিৰে 1 লাখে হ'ব এইটো। 1 লাখৰ বাহিৰে বেলেগ টকা আছামীগণে মোক ঘূৰাই দিছে কথা ভাউচাৰত মেনশ্যন আছে। Then
just a moment. Read the Exhibit 1 charge, page 3, on dated 19/2.
Exhibit 1 চেকখন dated 19/2/2009 bounce হৈছে. I got the information on 13/3/2009 from bank.
I knew that the check got bounced due to insufficiency found in. It does not say about the first bouncing.
This is the first bounce.
This is the first bounce.
First bouncing.
Okay.
Thereafter also it got bounced after payment.
Read that paragraph nicely.
Hello.
Exhibit 1 check on dated so and so. Bounce hoise.
Bounce hoise. I got the information on 13/3/2009 from bank about bounce of check white exhibit 3 dated 10/3/2009 received by me on 13/3/2009. I knew that the check got bounced due to insufficient fund
In their
in
account.
their account. এই উলিয়াব মই জনাও নোটিচ দিছিলো আসামীগণক চেক বাউন্স হোৱাত 30 দিনৰ ভিতৰত মই আসামীক দিওঁ পাই সত্য নহয় যে আসামীক মই 30 দিনৰ ভিতৰত কোনো ডিমাণ্ড নোটিচ দিয়া নাই on 16/7/9 is এই নোটিছত মই ৰাখো ৰিপ্লাই নোটিচ মই পাইছো Sofiul Islam advocate on 10/6/2009.
— 16/7/2009 he filed the case. Right? Notice is of 10/6/2009.
Twelve 6/2009. In that notice, your lordship will find on 13/5/2009 again submitted the check.
Where do I find that?
That annexure to page 15. That is in the notice itself. 12/6/2009 notice. Second paragraph, my lord. Second bounce is there.
So this is the first notice that he issued to you, 10/9/2006.
This is the first notice.
You mean to say by that time the payment, the debt
Yes,
was already liquidated?
33/2009 payment was made.
Liquidated.
Yes. And Exhibit C, regarding Exhibit C, your lordship will find just below the paragraph I was reading.
Hmm.
In cross-examination part.
A reply notice. So,
Exhibit C is the reply notice dated 10/6/2009.
under objection.
এই রিপ্লাই নোটিছখন মই পঢ়িছিলো কিন্তু বুজি নাপালো। নোটিছ লোৱাৰ পাছত মই বাউন্স কৰা চেকখন ঘূৰাই নিদিলো।
Read further.
এক্সিবিট B3 মেনশ্যন কৰা চেকখন বাউন্স হৈছে। সত্য নহয় যে 1 লাখ টকাটো কেছ হিচাপে মই ৰিচিভ কৰিছিলো। 1 লাখ টকাটোৰ বাহিৰে আছামীয়ে মোক বেলেগ টকা দিব লগা নাই। সত্য নহয় যে 1 লাখ টকা কেছ মই ভাউচাৰ বুকত চহী কৰিছিলো। সত্য নহয় যে B1, B2, B3 মোৰ নাই। সত্য নহয় যে। That means his signatures are there.
Who is PW2? It's a post.
BW2 मिलो।
PW. I think it's a postman. So your case is of simple denial that the amount having been
Amount has
liquidated,
been- yes,
so nothing further remains. No
Nothing.
debt, so the check utilization
yes.
is of no consequence. Now show me somewhere where in your have you taken this point before him? That have you crossed him on the point with regard to, comforted him with regard to that voucher, B4? B4 is the voucher, 33.
Yes.
Did you comfort him? Mr. Chaudhary, is there any B3, B4?
Is there, B4 is not.
B4 is the voucher, right? Mr. Chaudhary, is B4 the voucher?
B4 is
The voucher by
yes.
which you say that the payment was given.
was made.
Where is B4 voucher during the cross? Because it stops at B3 everywhere. Where is B4 being comforted? You get my point? If B4 is
I have
the,
got, matlab, B4
but
there is no
B4 if
mention
it is
about
not
B4.
given to him, then how do we accept that? He should have been comforted with B4. Then he would have disputed his signature. It would have gone for forensic.
Here, my lord, forensic. My lord.
In fact,
for
prayer was made.
Forensic examination, they given it was allowed, my lord. Delete.
Okay.
But allowing that also, my lord, they also did not challenge that, my lord, before the revision. After deciding by the my lord two court.
Nothing
High
is,
Court
if
assuming
the-
that
until and unless I don't find something very, something going vitiating the whole thing, I cannot reappreciate the evidence. But Mr. Chaudhary is arguing, so he said that the amount was paid back to
paid
you.
by.
So if the amount was paid back,
Yes.
so there is a voucher for that, whether you were comforted with that voucher during your cross-examination. Why the application for verification of the signature was made?
It was not pursued by the advocate.
It was rightly
is the
not pursued.
difficult-
Maybe he had the doubt.
But for doubt portion, my lord, signatures are very much there in the complaint petition, in the affidavit. In all over, your lordship will find his
See,
signature.
Mr. Chaudhary, you had an opportunity. Court permitted that. So that would have been the nail in the coffin for Mr. Chaudhary's claim. But you did not proceed with that.
That case, my lord, I'd like to refer section 73 of the Indian Evidence Act, my lord.
Court can my lord examine also.
Hmm.
Right, my lord, they should have challenged before the higher court, my lord, that was not done.
State, my lord, I am
Affidavit is
also-
there.
I can trying to convince your lordship if something can be done.
Now you have come to something that can be done. Why are you lowering your guard? Section?
I am
73
purely
evidence.
relying on section 73 and non-consideration of exhibit C. Section 73 of the Indian Evidence Act. Comparison of signatures, writing or seal with the others admitted or proved in order to ascertain whether a signature, writing or seal is that of the person by whom it purports to have been written or made. Any signature, writing or seal admitted or proved to be to the satisfaction of the court to have been written or made by that person may be compared with the one which is to be proved, although that signature, writing or seal has not been produced or proved for any other purpose.
Mr. Chaudhary, one doubt. Just, I may be on a wrong track. Kindly bring me back. The document, your case is solely on the basis of B4 voucher, right? So in B4 voucher, there is a signature, right? Now, that signature you will have to prove. It's up to you. So you have to cross him with that document. Say that this is your signature. What do you say? Then, so that document is not proved. If that is not proved, your whole case falls to.
Regarding exhibit C, my lord.
Exhibit C. What is that exhibit C?
Exhibit C and DW2. Page
Exhibit
26. This is prior to sending of the legal notice.
Page
26, my lord. Letter date is also prior, letter sending this is also prior, this postal fact report.
Now, have you proved the receipt of this by Jamiruddin?
Jamiruddin has accepted,
This
received.
This one?
Jamiruddin has said,
where?
my lord will find.
That is under objection.
No. under
10-6 is
objection-
under objection.
No, that I can understand, but he says, my lord,
Huzana Silu.
Huzana Silu. Exhibit C is the reply notice dated 10/6/2009 under objection. এই reply notice খন মই পঢ়িছিলো কিন্তু বুজা নাছিলো. It is admitted he has received it. Notice পোৱাৰ পিছত মই bounce কৰা চেকখন ঘূৰাই নিদিলো because that notice was for demand of that bounce check.
Okay, what is DW2?
DW2 is the author of that, is the legal notice.
Saiful Ahmed.
Saiful Ahmed. He said, my lord, he issued the Exhibit C and Exhibit C1 was his signature.
Okay, anything more?
My lord, certain judgments, my lord, regarding the duty of the court under Section 73 to follow the mandate of Section 73.
Exhibit C, okay. Okay.
I have serially numbered, my lord, 4 judgments are there. I will just refer the relevant portions. Lord, the first judgment, 1981 SCC 704, Murari Lal versus State of MP, paragraph 4, paragraph 12, your lordship may kindly have a look. Reading this paragraph 12. Ma'am. The argument that the
Just a minute.
my lord. Then
Next.
lord, the next judgment. AIR 1984 Calcutta, small paragraph 2. Even in the head note, your lordship will reference of paragraph 2.
Next.
Next, AIR 73 Punjab, Haryana, para 20 minutes.
Para?
Para 20. Last but 3-4 lines in the next para 20.
Here the High Court itself went and examined these signatures.
My submission is that, my lord, the records are before you. Signatures are there. His disputed signature is also there. His
Next one,
undisputed.
4. Item
Yes.
number judgment.
4, my lord, AIR 1979 Supreme Court 41.
Para?
Para 32, my lord. Para 32.
And 1999? You're relying on 90, K. S. Satya Narayana?
Yes, yes, ma'am. Para 7 is there. Last two lines, 2, 3.
Okay. Now tell me one thing. This exhibit C was there when the evidence of Mr. Jamiruddin was being adduced. It was there. Exhibit C. So we have something with regard to that. But before was introduced by whom?
Before my document, ma'am.
No, it was exhibited by whom?
Exhibited by the. Who is yes, yes. Ma'am. Before defense.
Defense witness. So that never found the, that was never there when the petitioner had made his submissions. So when you have not used the primary thing, which was the best document, how can you establish that fact from other interpretations? And Saiful Ali is just an agent of yours. He's an advocate. He's an agent of yours.
The notice.
He sent the notice basing on your instructions.
Yes.
He cannot have a personal knowledge of that.
My submission in the quasi-civil proceeding.
And what was the application you made for forensic science examination? Which is that application? You made any application? Mr. Chaudhary was telling.
Not, the engaged counsel, he wanted to sell, but later on.
No. Did he file an application?
No. Application was filed. Yes, yes.
Before trial court?
Trial court.
Then what happened? What happened to that application? Any orders passed? Order dated?
Eleven. Petition number so and so. Of documents. Out the prayer of defense by holding that house or opinion of handwriting expert to know were written by the same person. 16(1)(13) for taking steps.
Take any step.
The defense does not want to go for financial difficulty and poses upon the court to accept section 73 of the evidence.
That is order dated?
Is order dated by 19/1/2013.
19?
1/2013. 17,430. It appears that the earlier court argument.
Come to the conclusions, Ron.
My argument. I'm only relying on non-app. It's C, saying that, my lord, it's a quasi civil matter, my lord. Standard of proof required in such cases, my lord, preponderance of probability. By, my lord, proving exhibit C, I have established my case.
That is a case established on your own, without the same being confronted to the petitioner.
His cross-examination was.
We'll come to that. Just come to the conclusions.
Put the quotes below. Not averred a single sentence regarding exhibit C and DW2.
Okay, let us see DW2. DW1 or DW2? Who had produced the exhibit C? DW?
Exhibit C. So he is the author. DW2 is the author. DW1 in his one has exhibited. Lords, also look at the DW1's.
That's what.
Entire evidence. Look.
No, just show me the relevant portion.
Relevant portion. Exhibit, after exhibit A24, you'll also will find 1 lakh Disilu, Doisilu.
Cross or?
This evidence on oath. Second page.
Abu Shamat story.
story.
Okay.
মই গুছৰিয়াৰ পৰা সেকেন্ড পেজ মিল মই গুছৰিয়াৰ পৰা লোৱা টকা পেমেন্ট কৰিছো গুছৰিয়াক মই 1 লাখ টকা ঘূৰাই দিছিলো
DW1 is not the author, this is the person concerned.
Accused number 1 প্ৰথমে 1 লাখ চেক দিছিলো চেকখনৰ নম্বৰ 0002888 dated 12/9/2009 19/2/2009
Check Punjab National Bank.
চেক পাঞ্জাব নেশ্যনেল বেংকৰ আছিল চেক জমা দিয়া বুলি জনাইছিল চেক দিয়া সময়ত মোৰ একাউণ্টত টকাৰ ওপৰত 1 লাখ টকাৰ ওপৰত আছিল উক্ত টকাৰ পেমেন্টত বেংকে খেলি মেলি লগালে আৰু চেক পেমেন্ট নকৰিলে খেলি মেলি হোৱা কাৰণে গুছৰিয়াৰ মই চেক পেমেন্ট কেশ পেমেন্ট কৰিছিলো মই চেক দিয়াৰ আগতে টকা লেনদেন হৈছিল পেমেন্ট ভাউচাৰৰ জৰিয়তে এই 1,00,000 টকাও পেমেন্ট ভাউচাৰৰ জৰিয়তে দিছিলো পেমেন্ট ভাউচাৰ আমি ডিউলি মেইনটেইন কৰো পেমেন্ট ভাউচাৰত টকা দিয়া সময়ত আমি সহি কৰো B1 to B4 পেমেন্ট ভাউচাৰ ৰিসিপ্ট জমাবন্দীৰ জমিৰুদ্দিনৰ সহি আছে উক্ত এক্সিবিট বি সহি জমিৰুদ্দিনে মোৰ আগত কৰিছে B1 আৰু B4 টকা আমাৰ NGOৰ প্ৰেচিডেণ্ট আৰু ছেক্ৰেটাৰী সহি আছে মই দিয়া চেক ঘূৰাই বিচাৰি এখন নোটিছ দিছিলো এক্সিবিট C is the notice exhibit C1 postal receipt উক্ত চেক মোক ঘূৰাই নিদিলে 10/3/2009 বেংকে চেকখন ঘূৰাই দিলে and your lordship may come to cost partner
My NGO. Anything on the issue that I
B formula cost part B4 on the second last page second last page
before agreement number
জমিৰুদ্দিনৰ সিগনেচাৰ লোৱা পাতৰ বাহিৰে
voucherot 44
exhibit
voucher
B2
carbon
B3
copy
B4
আছে exhibit B2 B3 B4 carbon ফৰ্মত আছে
আছে
original নহয়
exhibit B4 ত agreement number
override
লিখা আছে
হয় লিখা আছে exhibit B4 to B4 original
জমিৰুদ্দিনক দিয়া হৈছে
দিয়া হৈছে উল্লেখ নাই
নহয় যে
so the original was also not produced okay yes Mr. Chaudhary
This is, my lord, the current findings of the two courts. And here main point is that, my lord, as that signature, even
where did you dispute that signature
B1 ত মোৰ নাই
B2
exhibit B2 মোৰ
B3
exhibit B3 মোৰ সহি নাই
B4 is not there
B4 it is not there
so that's
for, my lord, they have not brought, my lord, that is
they
why
have not brought but Mr. Chaudhary if I use the power under section 73 examine that the signature seems to be the same seems to be if that be so what would be the requirement of this court to do
before your lordship, my lord, when was, my lord, ordered to go for, my lord, hand
He did not go.
He did not avail it, my lord.
That is a presumption which can be drawn against him.
Yes, my lord.
Anything more, Mr. Chaudhary?
All, my lord. And and findings of the two court, my court has disallowed, my lord, their prayer. They could have very well come.
No, disallowed their prayer after because of their failure to carry out the order passed.
Also, my lord, they could have come to the higher court, my lord.
Huh.
But that was not availed, my lord. After, my lord, the judgment passed by the two courts, my lord.
We'll
The
examine.
court will, my lord, interpret.
But Mr. M. Chaudhary, learned, you are M. Chaudhary, learned counsel for the petitioner, also heard Mr. B. M. Chaudhary, assisted by Mr. U. Chaudhary, learned counsel appearing for the respondents. Hearing concluded, judgment reserved.
Obliged, Lordship.
I'm obliged.
I would also like to, Ms. Bora, learned additional public prosecutor, appears for the state response. Only thing is that I want to read on this some little bit. I'll see. Thank you. Yes. What happened to the other accused?
My lord Shahidul, my lord,
Huh.
and my lord Ainul, my lord, he is still on my jail, my lord.
Idol released.
In,
The order.
in connection with my lord Lakhipur PS, my lord, the present case.
Where is that?
Lord,
Order?
on telephonic instruction, my lord, I have inquired, my lord, IO, and this order also.
And Ainul has not filed an application?
This is not filed. Yasin.
Yasin Ali, Yasin.
Yasin.
We have, sir,
Okay. Where is the FIR?
it's on page 17. Okay.
Page?
17, 117.
17.
Yeah.
How long have you been in custody? In this case, shown arrest after that?
In this case, Lord, 74 days. In total, 112 days, Lord.
Okay. But Mr. B.K. So B.K. Soikia, P.K. Sohoria, learned counsel for the petitioner. You are in item number?
I'm 49.
49 to K. Rishikesh.
This is just,
Rishikesh Hazarika. Heard Mr. So-and-so, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor appearing for the state. The present application under section 483 of the Bharatiya BNSS has been instituted praying for grant of regular bail to the petitioner Rishiraj Sharma alias Rishiraj Hazarika. Rishiraj Hazarika alias Rishiraj Hazarika at Silobasan, page number 2 dozen. In connection with Lokhipur PS case number 101/2025 registered under section 147/148/149 of BNS 2023 dated read with section 10/13/16/18 bracketed B of the Unlawful Activities Prevention Act 1967. Also, a perusal of the FIR dated 23/7/2025 would go to reveal that one Yasin Ali was apprehended on suspicion of being involved in re-establishing links and reviving alpha bracketed I activities. Also, from the disclosures made by said Yasin Ali during his interrogation, the involvement of the petitioner herein having come to the forefront, the investigating officer had approached the court of the Chief Judicial Magistrate Gwalpara, praying for showing the petitioner to have been arrested in connection with Lakhipur PS case number 1025. So it is to be noted that the petitioner was in judicial custody at that relevant point of time in connection with a similar case being crime. What is that crime? Crime case? Crime branch PS case number 2/2025. Accordingly, the petitioner hearing was shown arrested in connection with Lakhipur PS case number 101/2025 on 4/8/2025. So it is to be noted that the petitioner in the meanwhile was granted bail by this court in connection with crime branch PS case number 2/2025 wide order dated
10/9/2025.
10/9/2025 in
Number 2.
BA number
871.
2871/2025. Also, the learned counsel for the petitioner has submitted that along with the petitioner herein, one Shahidul Islam was also apprehended and was behind the bars. Said Shahidul Islam was enlarged on bail by the court of the learned session judge Gwalpara wide order dated 16/9/2025 in bail application BA case number 440/2025. Also, Mr. B. Sharma, learned counsel, learned additional public prosecutor, accordingly, the learned counsel for the petitioner prays that the petitioner be enlarged on bail, on regular bail. Full stop. Mr. B. Sharma, Learned Counsel for the Learned Additional Public Prosecutor, submits that incriminating materials having come on record against the petitioner, his release at this juncture would be prejudicial to the investigation of the matter, and accordingly, the petitioner be not granted bail at this stage. Also, he further submits that the petitioner is found to be involved in similar offences, and accordingly, his detention would be required to be extended in the interest of investigation of the matter. Also, I have considered the submissions of the Learned Counsel for the parties and also perused the material. The case diary as produced has also been perused by me. Also, considering the materials brought on record, including the disclosures made in the case diary, considering the length of detention of the petitioner with effect from 4/8/2025, that is for more than 74 days, this court is of the considered view that the investigation may have advanced, and accordingly, the further custodial interrogation of the petitioner would not be called for. Also, further, a co-accused apprehended in the matter along with the petitioner, that is Shahidul Islam, has also been granted bail in the matter, regular bail in the matter. Also, subpara. Under the above circumstances, this court is of the considered opinion that though there are incriminating materials against the petitioner in the case diary, the petitioner having undertaken to cooperate in the investigation, his custodial interrogation may not be necessary for a fair completion of the investigation in Lakhipur PS case number so-and-so. In view of the above, the petitioner, Namtu Likidiba, is allowed to go on a bail of rupees 25,000 with 2 sureties of like amount, subject to the satisfaction of the learned.
CJM, my lord, Gwalpara.
Learned
Gwalpara.
District and Session Judge.
District and Session Judge.
Session Judge Gwalpara, subject to the following conditions. The petitioner shall appear before the investigating officer every 15 days and shall continue to appear till the investigation in Lakhipur PS case number so-and-so is completed. Also, Baki hai petitioner shall not directly, indirectly, etu diba. Petitioner shall not leave the jurisdiction of the Session Judge Gwalpara without prior permission. Also, any violation of the conditions, aforesaid conditions, would be a good ground for cancellation of the bail granted to the petitioner herein. With the above observations and directions, the present bail application stands dismissed. Case diary be returned. Case diary is returned to the additional public prosecutor for further forwarding the same to the investigating officer. So next to Likiba Lintu Gugoi. His date of arrest is
Same.
same. চব একে থাকিব কাম
BA number is different.
yo
I'm BA number, Lordship, in the prime bench case, Lordship, that is the 2496 of 25.
BA case crime branch BA case on number
96.
2496/2025 order dated 4/8/2025 huh? তাৰ পিছত তোমাৰ ইয়াৰ এইটো থাকিব your name
A Gogoi, Lordship.
PK Gogoi
B, Lord.
PK Gogoi বাকি সব একে থাকিব ঠিক আছে ডেট অফ অ্যারেস্ট একে থাকিব সব একে থাকিব disposal
President of Dibrugarh, Lordship.
wherever you are be there you take permission and go too much of liberty we cannot
Lordship.
we'll have to ensure both sides. We don't want you to be inside, young guys, so we have allowed you to go, but that does not mean that you will have everything.
Obliged, Lordship.
You'll get the orders only tomorrow morning. Today may not be possible. My dear, jodi hoy jay upload kori di.
Obliged, Lordship.
Ki hai tum? Oh. Where is Mr. Borua? Sarma, I have to rise. There is a division bench. I also forgot. Due to paucity of time, the present appeal could not be taken up. Accordingly, registry to list this matter again on when? বন্ধ খুলিলে ডেটটা দি দিয়া ডেটটো 30 31/10 okay thank you ডেট দিব লাগিব হে এই 30টা এটা গ'ল এটা বাকীকেইটা ডেট দি দিয়া